The Honorable, the Judges of the United States Court of Appeals for the Fourth Circuit. Oyez, oyez, oyez. All persons having any manner or form of business before the Honorable, the United States Court of Appeals for the Fourth Circuit are admonished to draw nigh and give your attention, for the court is now sitting. God save the United States and this honorable court.
Ms. Mulaney?
As well as the other class members with whom Tidelands Hospital System has taken their substantial portion of their final paycheck. I will begin by what the court has foreshadowed, I think, where they're going by asking us to do supplemental briefs and just address that issue first. With respect to whether the court, the district court erred with by not exercising supplemental jurisdiction, I believe that the district court did err, and they erred by not addressing the issue whatsoever. And because of that, the court abused its discretion.
I think that argument, and I saw that was being made by counsel, has got everything upside down, because Section 1367 grants jurisdiction to the court. And so the test is whether the facts are related in part to each other in the case. The court, once it has jurisdiction, has an obligation to decide the case. And what the statute does is, in deference to state courts, is that the court can make the decision if it wishes to based on those criteria. But that gives the court authority. It doesn't have any obligation to do so. It has the duty to decide the case once it's jurisdiction. So the real question is not whether the judge has satisfied the exceptions. The question is whether the court had jurisdiction. And that is 1367A. And it seems to me your complaint alleges it. It links them all. It talks about the termination being part of the FMLA case and part of the wages case, and it actually suggests maybe that wage was part of the retaliation in the complaint a little bit. And you allege 1367. Defendant answers a complaint and says, I agree, it's 1367, and the court exercises 1367 jurisdiction. How can you fault it for doing the job that Congress gave it? What you're saying is the court should have avoided that, but it has no duty to. That's just authorization for the court to send it back. But you guys start with an affirmative duty that looks at the authorization to send it back and say the court should have sent it back, instead of saying, why didn't the court, the court has to exercise jurisdiction given to it. And so I think the arguments just start at the tail end and try to figure out what the elephant looks like from the rear. I mean, I don't.
Thank you.
The microphone.
You have to stand at the podium with the microphone. Where's the microphone?
Right there. It's at the lectern. Yeah. That's okay.
Yes, Your Honor. I understand your argument, but I believe that
It's not an argument, it's an observation. It starts with the grant of jurisdiction. 1367 is a grant to the court of subject matter jurisdiction.
yes.
And do you agree that the court had subject matter jurisdiction?
Yes, I do, but I believe that when the court dismissed the FMLA claim, then the court had to make a finding as to why that jurisdiction would continue.
Where did you get that obligation? The court already has jurisdiction and is mandated to decide the case. The question is if the court chooses to avoid it, but the court doesn't even have to raise the issue that it's not going to. It can just decide it. And if the court wants to send it back, it has the authority to do so. but there's nothing that says it should avoid jurisdiction that's given to it. And the statute doesn't even start that way.
Yes, Your Honor. Then if that's the direction, if understanding that that's the court's position,
No, it's
then
not. I'm just reading the statute. I'd like, if it doesn't say that, then I'd like you to say so. But the way I'm reading 1367A, and then, of course, it says, once you have jurisdiction, the general principle is the court has to decide a case. That's the obligation of the court. And the court took jurisdiction. Now, your argument is the court should have decided to avoid jurisdiction because it had authority to do so. And sure, it had authority, but it chose not to. And it doesn't have to explain why it's deciding a case with jurisdiction. It has to explain why it sends it back.
well, I believe that the court, with respect to the South Carolina Payment of Wages Act, I believe that the district court clearly erred by dismissing the plaintiff's Payment of Wages Act claim.
Can I, just before you turn to the merits, and I understand maybe we ought to get to the merits, but normally I would take your concession that subject matter jurisdiction existed, but since it's subject matter jurisdiction, I can't do that. Help me understand why you think there was actually jurisdiction here. I mean, it seems like to me the two claims, so the federal claim was about why she was fired, right? The events leading up to being fired. And the state law claim is about what the company did after she was fired. And yes, in some vague sense, they all, they're the two sides of being fired, like they're opposite sides. But why is it that you concede that they're like a common nucleus of operative facts? I mean, there is a fact in the middle that is obviously relevant, that is being fired, relevant to the FMLA claim. It's not clear to me why that's like an operative piece of the state law claim, but they seem to me to be just the two sides of being fired, not sort of an integrated, linked set of stories.
Yes, Your Honor. I believe that they're very interrelated.
And help me understand, why is that?
Because as a result of her being fired, that triggered the Tideland's payment of wages deduction policy.
But would your claim have been different if she had not been fired and they made the same decision to withhold the money that she owed, which allegedly the contract permitted? I'm not trying to get to the merits. I just mean if she hadn't been fired and they garnished her wages, however you want to describe it, right, took money from her to pay back the money she owed, that'd be the same claim. The fact that she was fired matters not to the legal theory, I think, of your state law claim.
Well, I believe, especially in employment cases, that you have to look at the fact that they are interrelated, and that it would.
But why? But why?
Because I think that it would impose such a burden on the employee if you had to fight the fight in two courts, so to speak, in federal court.
I totally get that, but we don't exercise jurisdiction because it'd be easier, right? That's like what I'm trying to understand is what fact that's necessary for your FMLA claim is operative for your state law claim? Like what is the fact there that, what we look as a common nucleus, not a common nucleus of facts, but a common nucleus of operative facts? Like what is the fact that you think is operative under both claims?
Her termination.
Why is that? So under the elements of the state law claim, why is her termination relevant to that claim? Because
the termination, in effect, set into motion the acts that led to the unlawful deduction from her final paycheck.
But the deduction would have happened could have happened without being fired, right? I mean, it's not a necessary part of that story at all. I mean, I get, you may want to include it, right? If you were, making the arguments in front of a judge or jury, you might include the fact that she's fired, although not sure necessarily why, and maybe a court would keep it out as 403 because it doesn't have anything to do with the state law claim.
Well, I believe under the facts and circumstances of this case, Your Honor, it's my opinion that it does have a lot to do with it, and that had she not been terminated, then Tidelands would not have, by using this illegal and unlawful policy that they have, then they would not have taken a substantial portion of her last paycheck.
I mean, you could give a narrative like you're giving, but tell me, under the Gibbs lens, how you met the common nucleus of operative facts, just in that framework of the law, the precedent. I mean, because everything sort of ties, if I hadn't done this, I would have been fired. Where's the nucleus, you know, that common thread that's operative to both?
Well, probably the hospital policy and her employment would be what is operative to
Of
both.
course, the statute is no longer relates to the Supreme Court's decision, but is broader. Congress chose to say that it only has to relate from part of the same controversy. That's the hook. And your argument is that they're linked because the termination gave rise to the FMLA case, and the termination gave rise to the paycheck withholding policy.
Yes, Your Honor, that is my argument.
And I must say, in your complaint, beginning at page 44, you say, the defendant is continuing to retaliate against plaintiff. And then in 6 paragraphs thereafter, you allege all the retaliations, including the employment agreement that they reduced her salary. They suggested that they was part of the retaliation. I'm not sure that's factually supportable, but that's the allegation, the connection there.
Yes. At this time, if I may, I'm not sure if Your Honor had a question with respect to that.
All you have to do is say you agree.
I agree, Your Honor. Yes, I do agree. But I think that this, the wage policy, I know I'm here today because I think that this policy is illegal and it violates the South Carolina Payment of Wages Act. And it's been continuing for some time. I think that Tidelands Hospital has twisted this act and is using its role as an employer and also becoming a creditor as well. And I think that that's illegal under the act. I think that the district court erred by not giving the same protection to the payment of wages as it does to deductions. I think that under the statute, it's clear that you have to give an employee notice of the time and the place of when they will be paid. And by that same token, you would have to give them notice of the time and the place of when these deductions would take place.
I thought she had notice in this case. I thought when she was hired, she signed that form giving notice and explaining that those would be deducted from her paycheck, and she agreed to that.
May I answer the question? I'm out of time.
This, oh, sure, yes.
Yes, okay. Yes, Your Honor, I disagree that she had notice as to the time. She had notice with respect to the policy, but the Payment of Wages Act is a remedial act that's designed to protect working men and women so they know when they are going to be paid, so that they can have that money to pay the basic necessities that they need. And she did not have notice of the time of the deduction. What the policy says is when you separate from employment, you could not possibly know on your first day of work when your last day of work would be. And the point of the statute...
The policy sets up a final accounting. In other words, you're going to work here, and we're going to deduct from your pay bills that you incur while you're working here, and we'll account for that on the last paycheck. And she says, I agree. The only thing that's left open from the statute says the amount, I think, and while the amount is described by the amount she incurs, the specific amount can't be determined, of course, because we don't know what kind of debt she incurred. Here it was some medical bills that she incurred, I gather, that were deducted in part. They weren't able to deduct the full amount.
Well, first of all, the policy applies even if the employee has previously set up a payment plan. They could have been,
No, my point is that she signed it and authorized and agreed to it when she was hired.
yes, well, it's my position that policy, the bargaining power is very unfair. She had no choice but to agree to it, and she did not have a meaningful choice. But even so, she wasn't given notice of the time of the deduction. When working men and women need to know when they're going to get paid and how much they're going to get paid so that they can plan accordingly. In this case, she did not know when a substantial portion of her last paycheck was going to get taken, and it happens at the time of separation, which is at a time when you need your last paycheck the most, because that is,
Wasn't that part of the policy, that it would be her last paycheck that they would account?
yes, that was, but I believe that policy is illegal because it doesn't say the time. It gives an event, but that is not the same.
How could it say the time when she terminates? She could die, she could quit, she could be fired. I mean, it's impossible for a notice to give the specific time when that occurs, isn't it?
Well, and that's my point. If they cannot give a specific time,
Well, they
then,
gave a specific time, which is at the end of her, on her separation from the company.
but I would argue that that's not a time, that's an event. And so therefore, she wasn't able to make plans or have notice of when, in fact, that deduction would occur.
So you're making a facial challenge because it's absolutely impossible at that time she's hired to say what date she will leave. So you're making a facial challenge, really,
Yes,
per se, correct?
yes, Your Honor. Yes, Your Honor. Should I?
Your time is up, and I know we didn't get to your FMLA, so.
Okay, all righty. Thank you.
But you have time reserved. Mr. Bright?
Thank you, Your Honors. I'm going to apologize to the court. I have a little bit of laryngitis this morning, and I know I'll try and speak up and make sure everybody can hear me. Not sure where it came from. I want to go back to the question that Justice Niemeyer asked about the jurisdictional question.
Don't promote him too quickly.
I'm still a judge.
You've asked a very pointed question, and I'm in a very difficult situation. My client prevailed below in a very well-reasoned opinion by the district court. It explained why it dismissed on the merits the wage payment claim. We were asked to brief the issue of jurisdiction. We gave a half-hearted effort to explain that, yes, the court had jurisdiction. We tried to, I'd love to be able to hold on to a win that I already had. But when push comes to shove, and in all candor to the court, I don't think the court ever had jurisdiction of that state law claim. As Justice Niemeyer pointed out, 1637 talks about the same core of operative facts.
No, it doesn't. It doesn't. It talks
Well, no,
about
it does not, no.
facts that are part of the same controversy. It's a broad linkage, and it's 1367A.
1367A says, supplemental jurisdiction over other claims that are so related to claims in the action that they form part of the same case or controversy.
Yeah.
And then United Mine, the mine workers case.
Well, that's in the common nucleus of operative fact.
That's right.
But this was prompted pursuant to that. But this, I suggest respectfully, this is broader than the nucleus of operative fact.
Counselor, I think we've addressed that in a prior decision. Are you familiar with the Axel Johnson case where we said that 1367 and Gibbs are not different?
They're not, I was not aware of that case, but that's the position I've taken from the very beginning, and that's, I think, the point that's argued in our brief. I think the point I'm making is that whichever direction the court elects to go, I think the real question here is not did the court err by not continuing to exercise jurisdiction over this case, whether it ever had jurisdiction in the first place.
Well, that's the only question we really have to answer is whether it had jurisdiction.
I agree. And if-
And you, in your answer, said it did have jurisdiction. It doesn't confer jurisdiction. Parties can't confer jurisdiction, but you agreed to it. A plaintiff alleged it, you agreed to jurisdiction in your answer, and the court exercised it. And so now the question is, does the complaint support a sufficient connection between the two causes of action where a court can decide the case as a matter of power?
And again, as I pointed out, in our brief, we basically said, oh, yes, it does, and the court should continue to exercise jurisdiction, but in all candor.
And so, in your brief, you did, this is a first-time announcement you're making here, an oral argument, isn't it?
I'm merely commenting to the court that if the court is suggesting that there was not jurisdiction, then the bottom line is it's as if.
Well, we're questioning whether it is, but your position up to this point, before coming into court, was there was jurisdiction.
It's exactly right, Your Honor. We all entertained that erroneous assumption.
So help me understand why that assumption's erroneous, sort of the opposite of your colleague. I think this is quite hard, so I pushed her, and I'm going to push you a little bit. So what I would have thought you would have said, and I think Judge Niemeyer's point about the retaliation is a separate point, but what I thought someone defending jurisdiction would say would be, listen, they are the same operative facts here because they both depend fundamentally on the employment, right? Without the existence of employment, we all agree that both of these claims fail, right? There's no FMLA claim if you're not an employee, right? Nor can you bring the state law claim that's being asserted here without being an employee. And indeed, not just being an employee, but like it's the nature of the obligations of that employment, right? In the FMLA case, it's the statutory obligations of employment. And in the state law claim, the allegation is that it's the contract, right? We're looking at part of the employment contract, the agreement that she signed when she started. And so, while we talk about them being sort of a common nucleus of operative facts, it seems like to me, as long as we've got part of that true, right? That is, both of these claims fundamentally depend on her employment with your client, right? That is enough under Gibbs and or 1367 to the extent there's a difference between there. I'm not sure what it is, but under both of those standards, that's enough. They both stem from not the firing. Put the firing aside. I think the firing doesn't help. But they both stem from the employment relationship. And so you have to prove an employment relationship in both claims here. So why wouldn't that be enough?
And again, I'm not arguing against it.
I know, but I appreciate your honesty with the court this morning. You are grappling with the same problem we're grappling with. And so I'm not trying, this isn't a gotcha moment. I'm looking for help, right? And so I want to get your take on why. I mean, you're familiar with the case. You've spent a lot more time with it than I have. And you know more about these causes of actions than I do. But why isn't that the sort of operative fact here, is the existence and nature of the employment relationship, whether she was fired or not, is sort of a sideshow. It's really the employment relationship itself that's the operative piece.
I think that there are certainly been cases decided by this court dealing with other employment circumstances, which also include a wage payment claim where someone lost some element of wages as a result of having been terminated. We've cited those in our brief. And the court has said there's jurisdiction and found them that the jurisdiction existed. It is entirely possible, as we've said in our brief, that the fact that this arises out of the employment relationship, it all comes about as a result of the termination of her employment, that may be enough to constitute the same claim or controversy, or using the words of Mine Workers versus Gibbs, arises out of the same interrelated series of events and transactions, or the common nucleus operative facts would ordinarily expect them to be all decided in one proceeding. So I think, yes, that may be enough. I'm merely expressing my concern that section 1367A and using the same case and controversy language, that it does not.
Seems to me-
One distinction might be a little bit that the FMLA, the violation, the alleged violation, cannot occur unless you are an employee at the time. But the wage payment can occur when you're not an employee, because you're gone. It's a collection.
Well, I think the
Is
point-
that correct? Do you, because,
Yes.
because they're making the accounting, you could be separated, whatever, you're gone, but they pay you afterwards and they can enforce it. Can they not?
Again, I'm candidly saying, I think, I'm fine either way we go here. And I think the answer to your
I was trying to
question-
give you a ledge, but go ahead.
I think the answer to your question is, yes, they arise out of the termination of the employment, but the wage payment authorization, the deduction authorization, could arise at any point in time during the employment relationship.
Well, but it had to arise, I mean, yes, one happens before firing and after firing. That's what we talked to your colleague about. But they both are dependent on the employment relationship, right? When we talk about the state law claim, right? And I'm happy for you to talk about it at some point. I understand that, you know, that's a big part of your argument. It's fundamentally about this contract claim, right? I mean, it's effectively about her employment contract. Whether they can withhold the money or not is a question about that employment contract. And so that strikes me as sort of at least a reasonable way of thinking about these, both arising out of the employment relationship.
Well, they both arise out of the employment relationship, but I would suggest to you that they both also have separate issues involved. The Family Medical Leave Act claim is one.
They do, but just to carry forward a little bit of those questions, I think the notion that there's an employee-employer relationship is very important and may even be decisive, but I think this case presents the notion that there is a controversy between the employer and the employee. It's not just the relationship, but there's a controversy of the relationship, and the controversy matured, in this case, upon her termination. And the termination then triggered two events. One, a claim under FMLA, and two, a claim that the last pay deduction, which is set forth in the policy in the final check, the last pay deduction was challenged. Both arose, number one, out of the employer-employee relationship. Two arose out of the termination, which was the controversy between the two, that she was separated from them. And the fallout was an FMLA claim and a claim for wages, or challenging the wage withholding, because it says that will be accounted for in the final paycheck.
And I think that my answer to that question is the fact that the FMLA issue is one of intent. It's talking about this, because she had a serious health condition, was she retaliated?
Oh, it's different. There's clearly different. You know, that's beside the point. The question is whether it's part of the same controversy. The statute says part of the same controversy. And the question is whether the things I itemized you was part of the same. The controversy was the separation of an employee-employer relationship. That's the controversy. The consequence of that was twofold, as alleged in the complaint. Actually, manifold, because there was retaliation also alleged too. But the main consequences were she lost a job and she lost pay.
And again, I think that may be enough to establish 1367A jurisdiction and why this court should continue to address the merits of the.
I mean, this thing is an efficiency thing. Congress, we don't like to fragment the cases unnecessarily, and if you're right about your new position, you're just going to have to try that case again in state court. It's already been decided.
And my only answer to that would be, Your Honor, that under 1367D, the tolling provision for the statute of limitations would not come into play because the court, if the court never had jurisdiction, then it's as if the case had never been filed. And the statute of
Well, that's
limitations
another
has
issue.
to
You're
go.
going to have to argue that issue differently. I'm not sure you're right about that. But
Let me turn to the merits. I think that Justice Richardson's already referred to the fact that there was a policy. She got deduction was going to be made, how the deduction was going to be made, what the actual calculation was going to be, that it was going to be from her final paycheck. It told her specifically that she would be entitled to keep anything up to a minimum wage and everything else would be subject to deduction. The statute itself is a notice statute, and it gave her notice when those things were going to happen. It told her at the time of your termination, this is what will happen, and she agreed to it, and she signed it. Moreover, twice subsequent to that, she went through training programs or she was supposed to have gone through, she signed off on going through training programs where the exact same policy was discussed and shared with her. And the language of the policy never changed.
What your colleague says that you got to have like a date certain, right? It's got to be like March the 7th, 2022 at 7 p.m., right? Like the time has to be specified, not the time of an event, but the time must be specified. And so in essence, the statute sets up a system that can, as the chief alluded to, can never be satisfied. But which, you know, maybe that's what state law was designed to do. But help me understand why we shouldn't think about time as requiring, you know, some degree of specificity that was lacking here.
And I don't think there is a lack of specificity. I think there is a degree of specificity by telling you.
There is some, but you agree it doesn't have like Tuesday, March 17th, 2019, right? So why is that not required? For that contract to be effective, why is it not required to say, we're going to withhold this money, you know, on Tuesday, March 17th, 2027, right? We got to figure out that date going forward, and we're just going to pick that date.
Well, I think what the statute 411040C specifically says that it is the obligation of the employer to notify each employee at the time of hiring of the terms and conditions of employment. Section 411030A says that an employer may not withhold unless the employee had been given written notification of the amount and terms of the deduction. Well, she was told exactly the terms of the deduction. And again, I think the cases say that this is a notice statute. It doesn't require specificity. Ross versus Lingard was a case where there was a question about when was someone going to be paid a bonus, and the employer kept delaying the bonus for unstated reasons, and the court said that's not good enough. You don't have to give a specific date, but you do have to give us something that tells us when is this going to happen. There was specificity here. She was told when you are terminated, this is what will happen. And I think that's all that is required under the state statute. And I think that, as Chief Justice Gregory has pointed out, if at the time of hiring, which, by the way, her employment started in 2010, they would have had to have known that in October of 2018, she was going to be fired, and they were going to tell her, this is the date you're going to be fired, and therefore this is how this deduction is going to take place. No one knows that. We're not fortune tellers. We can't tell that. And you're basically writing that statute out of existence, which is not consistent with ordinary statutory construction. In this particular case, she was notified in 2017 of the debt that she owed. She was told by virtue of the policy itself the circumstances under which it would be withheld and how much would be withheld, how it was going to be calculated. The only thing she wasn't told was the specific date that it would occur and the specific amount of money. And no one would know that in 2010 when she was hired. And that would totally write the statute out of existence, which I don't think is what is appropriate. Again, cases in South Carolina specifically say this is a notice statute. And I think that she was given adequate notice. So therefore, we think on the merits, the case should be, the judge's decision should be upheld. With regard to the issue of the Family Medical Leave Act claim, there are two claims. One's a retaliation claim. One is an interference claim. Let me deal with the retaliation first. With regard to the concept of retaliation, we do not contest the fact that she can make a prima facie case. We have articulated a legitimate non-discriminatory reason for her termination, which was the receipt of 2 written Class 2 warnings. The first warning was when she didn't get BLS training, basic life-saving training, back in 2012, and she was given a Class 2 warning. In fact, that's a state requirement. She couldn't work as a nurse without having that training, and therefore that's considered a very serious offense. She received a Class 2 warning. She admitted that she knows of nobody else who didn't get a Class warning or a Class 2 warning when they didn't get that training. She's not aware of anybody who didn't get a warning for that. The second warning occurred when she threatened a fellow employee. I won't repeat the words of what she said. They're in our briefs. But she threatened to get into a fight with a fellow employee because she didn't like the way she gave a report. There are written statements from the employees who witnessed that event. They are a part of the record. The supervisor, while she didn't know about it until a month later, immediately conducted an investigation. She interviewed everybody that was there, and she asked plaintiff to give a written statement, and plaintiff refused. So based on that, she concluded that this person had threatened a fellow employee, and that's a Class 2 violation. And that constitutes, two Class 2 violations constitute a basis for discharge, and that's why she was fired. She was also fired for having received three warnings in a 24-month period, but that's irrelevant, and the court said so, because there is one reason that can be substantiated by the record, which was the receipt of two Class 2 warnings. And under those circumstances, there is no evidence of pretext. She's not been able to show that anyone else who got two Class 2 warnings wasn't fired. She acknowledged she knew if she got two Class 2 warnings, she would be terminated. And there is nothing in the record to suggest any sort of pretext other than counsel's argument that, well, I don't think she should have gotten a Class 2 warning, or I didn't say that. We've cited a case in our brief which stands for the proposition. It doesn't matter whether she says she said that or not. It's whether the employer reasonably and in good faith believed that she said that, and I think that the evidence supporting the investigation explain why that was a good faith belief. And finally, with regard to the interference claim, the only issue here is, did the fact that she was disciplined at some point in time by getting a written warning constitute harm that would trigger an interference claim? And our position is, she received no harm. She suffered no harm. The termination occurred because she got two Class 2 warnings, not because she may have had an absence that may have been covered by the Family Medical Leave Act at some other point in time. Unless you have any further questions, my time is exhausted.
Thank you, Mr. Bright.
Thank you.
Ms. Mulaney?
First, before I get to the FMLA issue, I just want to address very quickly my colleague's argument about time and saying that the policy did, in fact, give employees time. And I respectfully disagree.
Let me ask you on this. You know, this is sort of like arguing Alice in Wonderland. You want somebody to say in a notice that something will happen when that is totally conditional. It's conditional on her incurring medical bills, and it's it's dependent on when that's going to be paid. But both of those are just totally impossible to include in a notice. Now, I don't know, tell me what you think the notice should have said. If they want, their policy was, you can incur bills at the hospital, and we will account for them in your final paycheck. Now, the other alternatives might be, as you incur the bills, which still wouldn't be on a specific date, because she incurs a bill on June 5th, but that can't be known at the time of notice. And, or they could say, we'll do it on January 1st of every year. They could do that. But their policy was, at the end, when you're terminated. Now, it seems to me it's totally nonsensical to say the statute isn't satisfied because it doesn't predict accurately when she's going to be terminated, or separated, or quit, or die.
Absolutely, but and so therefore the policy is illegal.
Well, tell me what the policy should say.
There shouldn't be such a policy in South Carolina.
Well, they don't. The South Carolina law doesn't. They just say if you're going to deduct You have to give notice.
No, Your Honor, the South Carolina does have a policy. The state of South Carolina, unlike many states, will not allow wage garnishment for medical bills. So
This is not garnishment.
well, it's a de facto garnishment. And so by that fact, this policy is illegal. By the same token, you couldn't tell someone, you know, you're going to be paid when your review is meets expectations, and then we will pay you.
So you're saying that it is against the law of the state to have any kind of deduction for medical bills incurred or any other type of bills, because they talk about other types of bills. If you purchase a gown or you purchase equipment or do something else and put it on your account and they pay that from your wages, you say that's an illegal policy?
Well, putting it on your account is different. For instance, you could deduct for lunch if you say, you know, you can put, you know, once a month, we're going to take out, you know, whatever you ate in the cafeteria on your second paycheck so that the person will know, okay, you know, I'm not going to have $50 in my last paycheck because.
But why is that any more specific, right? We don't know what you're going to pay for lunch. Maybe I get a sandwich today, I get a soup and salad tomorrow, right? It's the second paycheck, but I don't know what date that is. I can figure it out based on the events, but I don't know that that's like March 17th.
But yes, you do. Believe me, working class people know exactly what date their paycheck is going to be and their bills and.
No, they know it, but it's not in the notice, right? Like the notice is just an event. Yes, they can figure it out.
That's correct, but that's different than a debt. That's something that, that's a meal. That's something part of their employment. But this, the hospital bill is a separate contract. It has nothing to do with their employment. It's separate. And not only is it.
It's a policy of their employment, and it relates to certain specified expenses. Like if you lose a phone that's given to you by the hospital, you have to pay for it. It's right here in the policy. If you buy a gown or tools, you have to pay for them, and it's part of the policy. So the hospital says, we're hiring you, and if you incur expenses from the hospital during that time of a particular ilk, then we will deduct that with your final paycheck.
The only part of the policy that I'm here today on is the part that pertains to hospital bills and being a debt collector. Not only is the hospital.
It's basically subtracting things that she has agreed to pay for and agreed to have it deducted from her by signing that, to having it deducted from her salary.
But she's only agreed to pay for it because she needs a job and because she needs
didn't have to
medical
take this
care.
job. It's a condition of the job.
But if you worked for Citibank, Citibank should not be allowed when you leave your last day of employment to take your last paycheck because you haven't paid off your credit card bill. You know, that is.
Why not?
Why not? Because it has nothing to do with your employment.
But if you agreed to it.
Because it's
You
unconscionable.
work for the bank, and the bank says, we're going to give you a credit card from our bank, and you can use it, but on the last day you leave, you agree to pay up in full the credit card balance. Part of your employment. Is that illegal?
Well, I think the credit card bill is different than medical care.
Well, you just use the medical bill.
We're using your example.
Yes, well, yes, but I think in the case I cited in my brief, the Costco case in California, the court did find that was illegal because they found that the employer was getting a benefit from that by the interest rates that they were getting from the credit card. So, yes, Your Honor, I do think that that's illegal. I think that.
Depends what the agreement is. If you pay off the balance, and that you agree to pay off any outstanding balance on the credit card we issued to you when you leave your employee, the day you leave, and if you don't pay it then, we will subtract it from your last paycheck. That's the agreement you sign when you work for the bank. And you say that's illegal?
Yes, because I think you should have to go through the garnishment. I don't think that you should be at a distance.
You know, a garnishment is a collection device where the creditor goes to the debtor's employer. The creditor is independent of the employer. Garnishment is a collection procedure. And so let's keep garnishment out of this. This is a method by which the employer accounts for debts between the employer and the employee incurred during the employment.
But it's debts that is a benefit to the employee, to the employer. And I
To
don't
the
think,
employee got medical treatment. The employee gets a robe. The employee gets a reimbursement, gets a new phone. I mean,
I don't think by virtue of being the fact that you are an employee, that you should be subject or be at more of a disadvantage
Depends
than
what you
someone who
agreed
is
to.
not an employee.
it depends what you agreed to.
You agreed to it because you needed a job, and that's why you agreed to it. I believe my time is up, unless your honors have any additional questions for me.
Well, I was going to try to give you, I know it's been going long, but I like to try to be fair. You started off, you want to talk about the FMLA,
Yes.
but then you went back to
Yes,
what you did
thank you.
before, so you never came back. So I'm going to give you 3 minutes.
Thank you so much, Your Honor. I really appreciate that. First, I disagree with my colleague and with the district court in that with respect to disciplining somebody for an FMLA-related absence is absolutely a harm. That is the very purpose and that is the very intent, to allow somebody FMLA leave, especially intermittent FMLA leave. That leave allows you to take that if you are sick or if a family member is sick. And by disciplining someone for taking that leave, that is a harm, because then the employee, of course, is afraid to take leave when they are sick or when they need it, because they don't want to lose their job. And so therefore, they structure their leave accordingly, and it essentially makes the FMLA intermittent leave null and void. If you're going to discipline somebody for taking it, that interferes, by definition, that interferes with the FMLA leave. And in this case, this was especially egregious because they were saying she got written up because she didn't use the words FMLA when she called in to say, I'm not coming in, I'm sick.
What's your response to the argument that we just heard, that she incurred 2 Class 2 warnings, and that the policy of the company is when you incur 2, you'll be terminated?
Yes, well, first of
And
all,
the two Class 2 were not FMLA related.
yes, Your Honor. First of all, I disagree. She denied threatening anyone.
I understand, but that's the reason they gave her the warning. And there was an investigation. She disputes that, but they concluded it was not an FMLA issue. It was a threatening a fellow employee issue, so they gave her a Class 2 warning. But my question is, they allegedly had 2 Class 2 warnings, right?
Allegedly, yes, but and I wanted to point out, Mr. Bright said something which was incorrect when he said they immediately did an investigation. That is not correct. In
He
fact,
said a month later.
okay. Well,
He said
I
after
apologize.
she learned a month later, he said,
Okay.
and then she immediately, when she learned, she conducted the investigation.
Okay. I think that with respect to they didn't even know what date she, quote unquote, supposedly threatened an employee. She denied threatening the employee. And to answer your question, Your Honor, I believe what the district court did was engage in fact-finding, which was an issue that should have been handled by a jury and not by a judge, with respect to whether, in fact, she had or had not incurred the second Class 2 warning. I believe that there was enough.
Is there any dispute she was issued 2 Class 2 warnings?
No, Your Honor, there is not. But I do believe there was a dispute with respect to whether the second Class 2 warning, whether in fact she had threatened someone, and also whether in fact it was a Class 2 warning. Even had she done the conduct alleged, it could have very easily been a much lesser offense. But the same supervisor that wrote her up for not using the words FMLA when she called in sick is the same supervisor that decided that it was a Class 2 warning. And so therefore you could see this supervisor's discriminatory animus towards my client and interfering with her ability to take FMLA. As my client stated, she felt that this supervisor did not want to be burdened by the fact when she used her FMLA by finding other people to come in and work. So Therefore, she wrote her up for the FMLA, and she trumped up this Class 2 warning to terminate her. So I believe that there absolutely was FMLA interference and FMLA retaliation.
Right. Thank you, Ms. Mulaney.
Thank you.
Mr. Bright, thank you for your arguments. We'll come down and greet counsel, proceed to our next case. Mr. Ballinger?
Thank you, Chief Judge Gregory. May it please the court. I'm the director of the Appellate Litigation Clinic at the University of Virginia School of Law, and it's my pleasure to introduce two third-year law students who will be arguing for Mr. Parrish today. Rachel Martin will be handling the opening argument, and Andrew Nell will handle any rebuttal.
Thank you. Welcome. Ms. Martin? Yes.
May it please the court. I'd like to start with the issue this court specifically asked us to address about the significance of Section 2107C. And then I'd like to speak to why Parrish's complaint was timely under Heck v. Humphrey, and then to the government's new 11th hour argument that Parrish's administrative claims were premature. First, on Section 2107C. That statute codifies the substantive timelines for appeal in Rule 4. Like the rule, it tells us when a court can, quote, reopen the time for appeal. But it does not speak to how an appeal is executed, including the procedures for filing and processing a notice of appeal. Those are governed solely by Rule 4, which Parrish satisfied, as the district court found, and the government does not contest. This court has long held that a notice of appeal, already on file, but premature, becomes effective when the conditions making it premature are resolved, without any need for a second notice. Parrish received notice the district courts.
Well, that's probably a difficult analogy because the premature appeal is filed before the appeal is actually required. But it doesn't extend the time for appeal. What it does, it recognizes an early appeal to be okay when the appeal is filed. I mean, when the time for filing the appeal. But in this case, he filed his appeal late and beyond the time that he could get an extension. And at that point, I mean, basically the case is over. There's nothing there. But Rule 4A6 provides an opportunity for 6 months to reopen, to file an appeal within a window of 14 days. And it says, actually, the district court may open the time to file an appeal. So when the court opened the window in this case, which was way beyond the appellate time, it created a 14-day window in which to file an appeal. And as we know, he didn't file an appeal in that period. So it seems to me this is significant in this case, not because your client's pro se, which I think we have to consider, but it's jurisdictional. It goes to our power to hear the case.
First, Your Honor, it says to reopen the time for appeal, not the time to reopen to file an appeal.
I'm reading of it it says the district court may reopen the time to file an appeal for a period of 14 days. Is that what you're reading?
No, I have.
2107 and Rule 4 are different. 2107 is what you're reading from, and Judge Niemeyer's reading from Rule 4. They're slightly different, right?
Oh, okay. Sorry, Your Honor.
I just had it right here in front of me. I'm not sure it's a significant difference, but time for appeal or time to file an appeal, it seems to me, could be thought of to be the same concept, right?
Yeah, so this, Rule 4, the specific, this court and the Supreme Court have repeatedly said that the requirements of Rule 4 should be construed broadly, such that even technical deficiencies in the rule should not lead to dismissal.
Well, you have to focus on the deficiencies. The cases you cited were deficiencies with respect to the notice, insufficient references to judgments or whatever, orders or whatever, but, and the intent to appeal particular aspects of a case. But here we're talking about something, as you know, is jurisdictional. The time in a civil case, the timely filing of an appeal goes to the power of the court. And Rule 6, I don't know of a case that said we should relax Rule 6 and to say that you don't have to file the appeal.
So the substantive timelines in 2107C are jurisdictional, and Parrish met those when he received notice from the district court 93 days after the judgment entered, and filed his joint notice of appeal and motion to reopen 14 days after that, which can be ascertained by the postmark. However, the exact how you process the notice of appeal, those are governed only by Rule 4, which is not jurisdictional. This is essentially the exact same situation as in Clark, where the document that functioned as a notice of appeal.
You say the time periods in Rule 4 are not jurisdictional?
So the time periods which are mirrored in 2107 are jurisdictional, but the exact procedures for notices that are in Rule 4 are not in of themselves jurisdictional because they're not codified.
No, I'm just talking about the time periods. We have here, we're looking at a time period beyond all extensions available under either the rules or the statute. And so he didn't file within 60 days of the order, and he didn't file within the excusable neglect period, and he didn't ask for an extension. So he's beyond all that period. The statute gives him one last look, statute and the rule, for 180 days. And it says you can file a motion to reopen. In this case, the motion to reopen was filed and granted. So now the motion's reopened, but the question is reopened to file an appeal or for appeal, whatever the language you want to rely on. And at that point, he didn't take advantage of the opportunity given to him to file an appeal.
Ms. Clark, you're about to mention it. Final opinion, Clark. Go ahead.
Yes, so in Clark, the plaintiff filed a motion for an extension of time. He did not file a notice of appeal, but this court construed that as including both of those documents. And so when the motion to extend time was granted, this court said that he did not need to file a second notice. Then the motion and notice that he had filed became effective. And every other situation in
But that's an
Rule 4
extension of time. That has different principles and different rules. The court can extend the time. A person files an appeal late, and the court can extend the time and consider that appeal appropriately filed. That's standard procedure. But that's a different rule. We're talking about reopening the case after the times have expired for extension.
In both cases, the notice of appeal would have been late when filed and premature in relation to when the motion to extend or reopen was granted. We don't believe that there's any real difference between extending the time and reopening the time for that purpose. In fact, in every other situation...
Can you help me understand? So that sort of raises the concern that I've got. So I look at 2107 and it tells us that you file after the judgment, right? And so that's satisfied. But then it sets up, that's up sort of, you have to do it after the judgment, but then before 30 days. Here 60 because of B, but either way, right? But that's the window. And then at the end of 60 days, that window closes. And then we have this 2107C that tells us you can reopen the window. But by definition, it seems like when I read the word reopen, right, it means that in the interim, it's still closed, right? I mean, the very nature of the word reopen means that it was closed before. And so help me understand how I can read the word reopen in the manner that you're suggesting. I mean, he plainly filed it in the period that was what I interpret as closed. And what I'm having trouble understanding is like how he could then file it in the 14 days, which is the only time that it is quote unquote reopened. Right? That word to me is the problem I'm having with your argument, I think.
So a few points. First, because the requirements of 4A5 and 4A6 are slightly different, you need to have received late notice of the judgment below for 4A6. Congress needed a different word to help courts keep them straight. And reopen just means that the time was reopened. It doesn't say when it was reopened from, whether it's reopened for then effectively for the entire period. And
No, it's actually quite specific, right? It says reopen, not just generally reopen for 14 days, right? I mean, it's like extraordinarily specific, right? I mean, it's not reopen retroactively. It's reopen for very specific.
Even if that's the case, in every situation.
What do you mean, even if that's the case? Like, I mean, it does say reopen for 14 days, right? I mean, that's what it says.
Yes, Your Honor, but in every situation where Congress or the courts thought to address the issue, a notice of that is filed before the time is open to appeal is made effective when the conditions making it premature are resolved, even if there's substantive changes in the order in the interim. And it used to not be that way, but the Rules Advisory Committee said they were concerned about the fact that many pro se litigants did not file second notices of appeal, and they didn't want it to be a trap.
All right, so they do that in 4A2 to the extent we're looking to the rules. I'm not sure the rules can change the statute, but if we look to the rules, like 4A2 gives us one example where that happens, right? Where if you file it after the announcement but before the entry of the judgment, then we'll deem it, even though premature, we'll deem it having been filed later, right? But we know, like, that's one exception, but you don't fall in that exception, right? Because you filed it after the judgment was entered, not before. And so that exception suggests to me that we shouldn't make up another exception.
Well, whether it's before the time is open or after the time is closed, in either cases, the time would not be open. And
right, but 4A2 gives us specific direction of what to do if you file before the entry of the judgment, right? And so it creates an exception for that situation, but by doing so does not create an exception for your example, right? And so you're asking us to read in a 4A2 equivalent when a notice of appeal is filed during the window closed period after the entry of judgment. And that's just like making it up. Makes a ton of sense, right? Like 4A2B might ought to include this very exception, right? I totally get your policy arguments, but what I'm having trouble doing is understanding how I can get there.
yeah, so I would say simply that Rule 4 and Section 2107C simply do not speak to how to treat premature notices of appeal. And
4A2 does, though. 4A2 tells us how to treat a specific type of premature notice of appeal.
They do not say how to do it in this situation, and the Supreme Court has long said that we should not take Congress's silence as being necessarily indicative one way or the other.
No, but the Supreme Court also tells us that when a statute or rule creates one exception, we should be very hesitant to create another exception, right? I mean, that's the idea that once you start creating a list of things, one exception, that we shouldn't create a different exception that doesn't comply with the statutory, or in this case, rule-based demands.
That's an exception, though, for the 30-day notice issue. Like, Congress didn't necessarily address exceptions for the 4A6 provision. I presume that neither Congress nor the Rules Advisory Committee foresaw this sort of situation. Does that answer your question?
Sure.
Okay. Moving on, the core issue in this appeal is the timeliness of Parrish's complaint. And the only thing this court needs to decide is that the district court erred in choosing June 3rd, 2016 as the date when Parrish's disciplinary proceedings were favorably resolved for the purposes of Heck v. Humphrey's tolling rule. If a government has conceded error, they concede that Heck applies and they concede that it told the statute of limitations through January 25th. This court should not reach their 11th hour argument. It is waived that Parrish's administrative claims were premature. It is waived and directly contradicts their argument below. Your Honor, I see my time is up. If there are no further questions, may I be seated?
Thank you, Ms. Martin. Mr. Palmer?
May it please the court, my name is Jordan Palmer. I'm an assistant United States attorney for the Northern District of West Virginia, and I'm here today representing the appellee defendant, the United States of America. The district court's dismissal of plaintiff's claims should be affirmed in this case. This is a procedurally complex case arising out of inmate Dante Parrish's various allegations of malfeasance by the Bureau of Prisons and charging him with killing or involvement with a killing while he was incarcerated, and his eventual expungement of these charges. The underlying alleged facts in this case aren't particularly relevant here today because this case is here on a litany of procedural grounds. Overall, Parrish will not concede to any procedural bar to the filing of his Federal Tort Claims Act complaint. According to him, FTCA SF-95s can be filed before a claim is ripe. Plaintiffs have no requirements under the prison mailbox rule other than saying the complaint was placed in the mail on time. The United States sovereign waiver of immunity under FTCA claims gave tort litigants up to a 6-year statute of limitations. His very narrow SF-95s can encompass a litany of different claims, and plaintiffs can make a whole host of novel factual allegations in response to a motion to dismiss. Factual allegations which actually contradict their pleadings up to that point, and if a non-mandatory reply is not filed, the defendant waives any arguments based on those new facts forever, even if those arguments are jurisdictional basis.
So I want you to talk about the 2107 issue, but since you mentioned it, can you just sort of briefly help me understand under 2401, the sort of alternative argument that's made here that where it says or, in 2104B, it means or, and you say it means and. Can you help me understand why we would read that or to be and?
Yes, Your Honor. Parrish argues that 2401 is disjunctive, and effectively every court in the United States is being irrational and mistakenly reading it as saying that an FTCA tort litigant needs to bring their claim within 2 years and suit within 6 months of agency denial. Under Parrish's reading, if a tort plaintiff presents his claim to an agency within 2 years, he's treated like a non-tort plaintiff and benefits from a 6-year statute of limitations. But if he brings it after 2 years, the limitations is shortened to 6 months after agency denial.
No, I don't take that to be the reading at all, right? What I understood him to be saying is that every action has a 6-year statute of limitations, right? There's an additional limitation on tort actions, right? But that's in B.
I believe my understanding of plaintiff's position is that they're effectively giving plaintiffs an incentive for filing early.
Yeah, no, it's an odd, reading the language as it's written leads to a little bit of an odd result. I'm not sure it's an absurd result, but it's an odd result. I mean, fine, but you know, we sort of take the text as we got it, right? If Congress messed it up, they can fix it.
I think the Ellison Court, which I believe was a case out of the Fifth Circuit, demonstrated most clearly how the statute should be read. You know, a statute that precludes an action disjunctively if plaintiff fails to meet either of 2 requirements generally is going to be the same as one which requires conjunctively a plaintiff to meet 2 requirements. And here, it's a disjunctive. If you don't meet either of these, or, then you don't get to make your case. You're untimely.
Since in the negative, it says an action is barred by A or B,
Yes.
then if either is satisfied, it's barred. Is that the way you read it?
If something's not
barred,
satisfied.
if something is barred by A or B,
Yes, that's
then
correct.
either one of them will bar it.
That's exactly right, Your Honor.
So totally with you on that. And if the statute said it's barred by 1 or 2, but it doesn't say that. It says barred unless presented to an agency or filed within, right? So it's the opposite of by. The by example actually just changes the statute.
It's certainly not the most clear legislative craftsmanship, but I think maybe the way to understand it would be action shall be forever barred unless this circumstance arises, it's presented within 2 years, or unless this circumstance arises, it's begun within 6 months. It's still, I understand it's an or, I understand it's not written precisely under either reading, frankly, I believe, but this one seems to follow from the not only intent of this legislation, but can be read this way literally.
Judge Richardson raises the interesting point. It's sort of like a double negative built in, and the logic starts to fall apart at that point.
It's a little bit difficult. I think that this is the correct reading, and I think that there's no reason, and this is frankly, this is the way this court has read it under Henderson. Now, that case wasn't, this issue is not.
That's not binding on us, right?
Yeah, I would agree, Your Honor. It's not binding, but this is how this court has interpreted that statute, at least briefly in passing. Turning to the jurisdictional issue that the court's addressed at length in the opening argument here. The United States does not dispute that Parrish's appeal should be considered timely. This court has a general policy of construing notices of appeal liberally, especially at pro se filings. And given this court's determination in Clark v. Cartledge that even a pro se motion for an extension of time to file an appeal should be construed as an implicit notice of appeal, it seems to follow that in a case where an appellee actually filed a notice that was construed.
You know, an extension, both sides collapsed the extension jurisprudence with the reopening. The extension is actually keeps the case in play. So somebody files an untimely appeal. The court can ratify that by granting an extension, so long as the statute's complied with. The gates that were given by the statute and the rule for extensions were all foregone in this case. The time periods were not satisfied. You have to appeal within 60 days, and you have to seek if you want an extension, you have to file within the excusable neglect period.
Yes.
But so at that point, everything's dead in the case. The case is over, so to speak. Everybody used earlier the word closed. And that can go up for 5-6 months. On the 179th day after the judgment, somebody can come in and say, I want to reopen. Court can grant it, and at that point, it seems to me, it suggests that then you should file your appeal within the 14-day period from the order reopening.
Yes, Your Honor. I think it's probably.
But that's not an extension notion at all. Extension is an existing case where you can extend it. And this is reopening, which is a totally different concept.
It seems like the government is well placed in not contesting it because it's consistent, I think, with this court's precedent in Clark, the case in Evans. I mean, it is the law doesn't require a futile act in that sense. It's about notice. I mean, the previously filed notice is still in the breast of the court, and so when you open up the time, it's still there. It just makes no sense to say, oh, it's almost like playing Simon Says. Oh, it's there, but you didn't say Simon Says. But so I think it's consistent with common sense, our precedent, and I understand why the government did not oppose it here.
Yes, Your Honor. I think it would be disingenuous for the United States to take the position that we weren't on notice that Parrish wanted to appeal.
But help me understand, I mean, because Clark, I mean, I get notice is like the central point coming out of Clark, but Clark is like very explicit to say, right, yes, it's notice, but it still must be timely. And almost like it, highlighted or underlined, like the timeliness, which wasn't an issue in Clark, right? Clark sort of acknowledges is a separate story, right? I mean, I guess I'm having a little trouble understanding why you think Clark really bears very much on what we're doing. Clark absolutely says, for purposes of Rule 3, right, we're going to be pretty functionalist about did you have notice, right? But timelines are not about notice, right? They're about finality or, lots of different ideas we could talk about timeliness. But Clark sort of acknowledges that timeliness remained a requirement of whatever notice was given, right?
I don't think there's any dispute that what was construed as a motion to reopen was timely. It was that notice of appeal was filed within 14 days of when he received the court's decision, or when the district court determined he received it on June 25th. He files, it's postmarked that he filed the notice of appeal.
Yeah, but the question is whether the notice of appeal is timely.
The notice, it was construed as a motion by this court. It goes back to the district court, and the district court decides, yes, we're going to reopen the time. Parrish does not file a second notice of appeal. He simply didn't. It's really whether or not he needs to either file a second notice or if it's reasonable for the district court or for this court to construe that original notice as a notice motion combination, particularly for a pro se filing. And the United States simply doesn't dispute that it's appropriate for this case. Moving on to another procedural issue.
Well, you know, if we construed that as a notice of appeal, then he'd be out altogether because we don't have the power. I mean, you know, it seems to me we sort of ignore the Supreme Court's decision in Bowles versus Russell, and it was pretty clear and pretty precise. It goes to the very power of the court. It's not notice. It's not equitable. They rejected all those notions. They said it's a timing issue, and we have routinely dismissed appeals one day late because goes to the power of the court. And so if we treat his notice of appeal as a notice of appeal, he's out of court. It's untimely, no subject matter jurisdiction. The only benefit, and he couldn't get an extension then either. He's too late for an extension. So the only thing we could give him the benefit of is a file to reopen. And we gave him the opportunity to reopen to file an appeal. And the district court granted the motion to reopen, and the statute says from the date that court enters that order, he has 14 days to file an appeal.
Yes, Your Honor. I understand that timeline.
I don't see how we can play with that timing.
Well, I mean, I think it's just whether or not that notice, which was construed as a motion, could be construed as a joint notice.
It's not a construction issue. If it's a notice of appeal, he's dead in the water. If we took it on the face as a notice of appeal, everybody recognizes it's in the closed period. It's nonsensical, doesn't make any difference. You just dismiss because we don't have subject matter jurisdiction. The only hope he has is if we treat it as a motion to reopen. Now, the motion to reopen can be filed many months after the judgment. And it's the wild card.
Well, the notice was construed as a motion by this court. It
Yeah.
came up the first time after the notice of appeal was filed. This court sent it back down. And
Can I ask a slightly different way? I just want to make sure I understand the government's position. So imagine a hypothetical, which is not our case, right? But, 90 days after the entry of the judgment, somebody files a motion to reopen, right? On the 91st day, sort of a separate day, he files a notice of appeal. On the 100th day, the district court grants the motion to reopen for 14 days, right? Is your position that the notice of appeal filed on the 91st day is sufficient, that it springs forward into the 14-day period, and so we should deem it filed in that? Because would that work? Is that, under your theory, that suffices?
Your Honor, I'm only prepared to address the facts in this case today.
Well, this is a hypothetical, and you're here to help us, so give me your best shot.
I understand, Your Honor, but this is, I think that if we run too far afoul of the facts here, we're going to lead to a lot of difficult circumstances. And
What's your
I'm
answer
not
to his question?
Right, but what I'm trying to understand, right, is that assume, all right, if you don't like the hypothetical, I'll do it on this case. I'll ask you the same way, right? So assume I interpret what he filed in this case as both a motion to reopen and a notice of appeal, right? And then the court much later grants the motion to reopen for 14 days. Help me understand why the notice of appeal that was filed during the closed period, right, after the 60 days had run and before the motion to reopen was granted, why or how does the notice of appeal that was filed spring forward into the 14-day period that's reopened? That's what I'm having trouble with.
I think it's up to either this court or the district court's determination of whether or not they want to construe it that way. The 2107 is
No, but that's not construing it, right? Because that's what I'm trying to do. I'm trying to take away this construction argument you're making, right? Because I've already construed it as a notice of appeal, right? And my question is not whether I construe it as a notice of appeal. My question is, why does it spring forward into the 14-day period that's reopened, right? I don't care. It is, let's call it a notice of appeal. That's fine. But it's not filed during the 14-day period of reopening. And 2107C says it's only reopened for 14 days.
I think it comes back to the construction issue, Your Honor.
How?
Because if the district court wants to construe or is willing to construe that notice in motion, that notice as being filed either simultaneous with the granting of that motion or afterward, it has the purview to do so. And the statute, 2107.
Wait, so it can just pick? I mean, we had this issue come up in another context. Like the district court doesn't get to pick when something's filed, right? So we interpret this in lots of other statutes. When something is filed, it is a very specific term with respect to litigation, right? And a district court, for example, because there's no payment of IFP fees, can't determine that it has not been filed. We say filed is when it's submitted to the court, right? So the district court doesn't have the power to change when something's filed as a general matter, right?
Sure, yes. I think it'd be similar to Clark then. They construed this motion, or excuse me, they construed a motion for extension, strike that. They construed a pro se motion for extension of time to file an appeal as an implicit notice of appeal. It seems to be the inverse of that, is all we're dealing with here, except that was under Rule 3, admittedly.
The district court didn't construe it the way you suggested, though, that springing forward. The district court said, pursuant to Federal Rule of Appellate Procedure 4A6, following a thorough review of the circumstances of this case, the court reopens the time for Parrish to file his appeal for 14 days following the entry of this order. That was the court's statement.
Yes, Your Honor.
And so it seems to me, you read that, he has 14 days to file his appeal.
Yes, Your Honor, I understand that that's the case, but I'm going to be an expert in this court's procedures with the clerks for the lower court, but on the very same day, the supplemental electronic record was transmitted to the Fourth Circuit.
Well, fair enough, but that doesn't have anything to, that's an accommodation, that's an administration of the case.
Doesn't that occur when a notice of appeal is filed?
Well, he has to file his appeal.
You're right, the same things occur. I mean, it's amazing that a pro se litigant being put to this kind of task for, I think Evans said it so well. It says, in a situation that would amount to no more than paper shuffling. The appeal is there. It said it very aptly. The appeal is there. I mean, and to find somebody, it's almost trying to find, that's what is in Evans, this is in Clark, but then find to parse this out in a pro se case when the notice of appeal is already there to say, well, 14 days was open. I think most people say, well, I've already done that then. If you haven't filed one and you don't do something in 14 days, there's nothing there. But to say that, I think it's inconsistent with our precedent. And for this panel to, I think, change that. And I appreciate it very much, Mr. Palmer, for your take on the argument, because normally we tell people when you haven't put something in your brief and haven't said it, you can't argue. Now you're being forced to argue something when you said just the opposite is not an issue. But I think it's pretty clear from our precedent. It is, exactly. It's amounts to no more than paper shuffling. That's what we said in our Fourth Circuit precedent. It's the same thing. But go ahead.
I'm running low on time, but if I could briefly move on to some of the other issues. There are 3 possible dates that Parrish's claims accrued. One is June 3rd, 2016, when the rehearing was ordered. The other is January 25th, 2017, when the rehearing actually occurred. The final is October 18th, 2017, when the report from the rehearing was executed. The parties in front of this court agree that Parrish was incorrect in his SF-95 as a complaint. The claim did not accrue on June 3rd, 2016, and that's the date that was used in the initial motion to dismiss that the United States filed in the lower court. The United States contends he was not exonerated pursuant to Heck until October 18th, 2017, though Parrish implies that the United States disclaimed this argument in its response. That's not true. We indicated that nothing turns on that issue because we believe that under the January 25th or October 18th date, Parrish's claims were premature. The only difference being under the October 18th, 2017 date, his complaint actually would have been premature in addition to his SF-95s. And there are two intertwined reasons why Parrish's SF-95s were premature. One is the Heck Doctrine, the other is the Prison Litigation Reform Act. And I see I'm out of time, Your Honor. I can stop now unless you want me to finish this thought.
Well, you won't have any time to finish it. All your time is in one bash, but you want to take a couple of minutes to, because you did get burdened down with something you never made an issue of. Go ahead.
Yes, Your Honor. I'll be brief. We aren't contending that the claim should be dismissed for a Prison Litigation Reform Act jurisdictional issue. It's an FTCA jurisdictional issue. Now, the PLRA and the Heck Doctrine are all intertwined in it, but it's a lack of jurisdiction under the FTCA. Parrish's PLRA administrative remedy process was still pending. He had not been exonerated pursuant to Heck until at least January 25th, 2017. He files his SF-95s in the spring of 2016. So he's effectively trying to kick off his FTCA claim before his claim had accrued under Heck. It's somewhat irrational for a claim to be able to begin process before it's accrued under the FTCA. And as the FTCA is a jurisdictional statute, which is well established under Henderson, and a number of cases cannot be waived, the court really lacked jurisdiction to address his case. Thank you.
Thank you, Mr. Palmer. Mr. Nell?
Thank you, Your Honor. I'd like to pick up with the point that the government just left off on, whether or not this court has jurisdiction under the FTCA. So first off, I'd say Kwai Fong Wong made clear 2401 is not a jurisdictional bar. The government's arguments that the Heck rule somehow applies in the agency context suffers from two forfeiture problems, and it's also wrong on the merits. It's forfeited because even if Heck did apply in the agency context, the Bureau of Prisons didn't rely on it in this adjudication. It's forfeited because even if Heck did apply in the agency context, they didn't rely on it in the district court. And it's also wrong on the merits because Heck simply doesn't apply in the agency context. Going to why it's forfeited, I point this court to the Ninth Circuit's holding in Reyes, where the court made clear whatever procedures the Bureau of Prisons might have when it comes to adjudication of these claims, if the Bureau itself chooses not to rely on those procedures, it can't then go into district court and fault the inmate for not complying with those procedures. And the Ninth Circuit's holding in Reyes collected 8 other circuit courts that reached the same conclusion, and that's just a longstanding principle of administrative law. It's also forfeited because the government didn't raise this below, and the Supreme Court made clear in Jones as well as in Woodford that the Prison Litigation Reform Act is not a jurisdictional bar, it's an affirmative waivable defense, and the government didn't rely on it here even after Parrish himself raised the issue. And finally, it's wrong on the merits because Heck is simply a rule about when you can get into federal district court. It says nothing about what procedures the Bureau of Prisons uses within its own adjudicatory process. And it has to do with the historic role of habeas in courts, that when you go into federal district court, you can't attack the merits of your prison discipline or your confinement except through the habeas remedy. But there's nothing stopping the Bureau of Prisons from simply having a unitary process in which they say, file a single form, list all your grievances, we'll decide if you were wrongly disciplined on the merits, and also give you a dollar value if you were. And we think it's telling. Heck has been on the books now for over 30 years, and the government can't point to a single instance, a single case, or anywhere in the Code of Federal Regulations applying anything like a Heck bar. In fact, the only thing that the CFR says about how you comply with the FTCA is in 28 CFR 14.2, and all that says is that the inmate has to file the standard Form 95, listing their grievances and attaching a sum total dollar to their claims. And Mr. Parrish did both of those two things here. So he fully complied with his obligations under the FTCA. Briefly, Judge Richardson, I'd like to touch to your questions earlier about the language of 2401. We believe to the extent that this court has any concerns, you don't necessarily need to resolve whether or means or whether or means and to resolve this case due to the government's concessions. But that said, I think you touched on the heart of this, that the language of 2401 does not use the word by, and what the Ellison court did, that's the Sixth Circuit's holding, is they changed the language to read an if not. And by what I mean by that is the Ellison court said that the tort claim shall be forever barred if you don't comply with the first requirement or if you don't comply with the second requirement. But that's not what the language of 2401B says. It has two unless clauses, and those are two independent exceptions to the general rule that tort claims against the
So
United
tell me
States.
why it's not absurd to read. I mean, sort of, let's start with the idea that it's a little odd to read it as or, but tell me why it's not absurd.
So the reason why I think absurdity is a fairly high bar, and this court would have to say essentially the statute doesn't operate as written, and it clearly does. The way the statute works is that you either present your claim to the agency within 2 years, and if you take longer than 2 years, you're going to face a greatly shortened 6-month statute of limitations. But if you do timely present your claim to the agency within that 2 years, you then face the 6-year statute of limitations that all people suing the United States.
All right, so why do I read B as sort of an addition to A instead of an exception to A? So you might read A as saying, listen, the general rule is 6 years, but for tort claims, we have a different set of rules, right? An exception, not an addition. And that's the, 2 years or 6 months. But if you read it that way, then B would mean in year 10, if you submit to the agency and they deny you because it's untimely, you would then still have 6 months to show up. Do you understand?
Well, so I don't quite think that's how it works. So let's say on your hypothetical, you go to the agency on year 10 and the agency denies your claim. At that point, you're already outside that 6-year statute of limitation.
But why isn't the specificity of B governing over the general of A? So in other words, A is like, yes, this is the general rule. B says for tort actions, and what we have here is a tort action, this is what the rule is. It's barred unless these two different rules. And so that specificity on tort actions overcomes the general rule in A. Why don't I read it that way?
So I guess I'd have 2 points, Your Honor. The first is that I think as a general rule, we should generally read statutory provisions to work in unison instead of in tension unless there's some indication that one is meant to be an exception to the other. But second, directly to your exception point, 2401B is an exception to A, but it's a limited exception. So it's not a wholesale, we're completely disregarding what A says. It says that in these tort claims against the United States, that we're going to have a slightly different procedure. And we want you to go to the agency first, and we want you to do so in a timely manner. And that's why we're attaching the 6-month limitation for district court filings for people that don't go to the agency earlier. But I think if you just read 2401B in isolation, you would reach the problem of the statute plainly says or. And so it most naturally reads, why would Congress say do one or the other? It would seem like you then have no window to go into district court if you present it within 2 years. And the reason is because the A is there. And so Congress understood when they were drafting the language of B that there was still this general rule of A that would govern for individuals that did present their claims to the agency within 2 years.
So your view is that in year 10, when the agency denies and I file within 6 months, that's barred because of A, even though I complied with the literal language of B.
Well, at that point, you wouldn't have complied with the literal language of B. You wouldn't have presented your claim to the agency within in 2
Yeah, but it's or. That's the whole point of this,
Yes.
right? Is that the or that I'm satisfying is I filed within 6 months of agency denial, right? And so year 10, I file with the agency. They say, this is untimely, denied. And I say, okay, well, I can satisfy B. I definitely failed on the first one. I'm not within 2 years, right? But year 10, right, I can still file within 6 months of that letter. And so I've satisfied B, even though I'm in year 10.
So that's why I think that the language of A is there. Is it's an outer boundary for this
Right, your
court.
point is that I still would be barred, even though I satisfy A in my hypothetical.
Yes.
B, even though I satisfy B in my hypothetical, A would still bar me.
Correct, Your Honor. Your Honor, I see them out of time. If this court would like, I could briefly address some of your concerns about the notice of appeal. If not, happy to leave it.
Well, I've been consistent with, I'll give you a couple of minutes to say what you need to say.
Yeah, so Judge Richard, I just wanted to pick up on your questions earlier about 4A2 being one exception. And I think it's important to understand the case law that went on before the rules were amended. So before the provision in Federal Rule of Appellate Procedure 4A was actually codified, all of the circuit courts in the United States had already been creating this exception. There was nothing in the rules that told them, nothing in the statute, but all the circuit courts understood it simply made no sense if you filed a notice of appeal before the entry of judgment to then require a second notice of appeal. What 4A2 did was codified what all of the circuit courts of appeal of the United States did. I think if you look at the general case law in this area, it's unanimous on the fact that we don't do what Judge Gregory called empty paperwork shuffling. That all we want to do in these notices of appeal is make sure that we know who's appealing from what judgment and to what court. As the government concedes, they were certainly on notice, and had Mr. Parrish, instead of labeling this a notice of appeal, labeled it a motion to reopen as this court construed it, then we'd be essentially in the situation of Clark. And so it seems rather odd to say, well, because he filed an actual notice of appeal in this case, he should be treated more harshly. And I think, to your question about it springing forward, well, the way it works when you file a notice of appeal before the entry of judgment is essentially that. It's on record with the district court. It's not timely under the rules, but once that judgment is entered, it then springs forward. And that's essentially exactly what happened here. It was untimely, but was still docketed with the district court. And then when they reopened that time, the notice of appeal on file with the court was now timely.
Right. It didn't have to spring forward. It never evaporated. Go ahead.
Correct, Judge Gregory. And so we think, particularly given the situation in Clark, it has to be the case that an actual notice of appeal can't be treated worse off than something that didn't have a notice. And Judge Niemeyer, to your questions earlier, of course, your dissent in Clark was concerned about this very issue of notice.
Yeah, he disagreed with
Yes.
the precedent.
But no one disputes here that the government was on notice. It's why the government conceded it in their briefing. It's why they conceded it before.
Well, I don't think it's an issue of notice. I think it's a Bowles issue. A Bowles issue talks about the timeliness of appeal, and the rules have been set forth both by Congress and the Rules Committee about the timing of appeals, and they've been treated as jurisdictional. So we're in a little bit of a different ballpark than when you prematurely file an appeal before judgment. And it seems to me that's a peculiar circumstance. Sometimes it's very technical because some judgments, as you know, judgment's supposed to be on a separate paper, and there's all kinds of other requirements for judgments. But here, all the judgment has long been entered. The time for extension has passed. The case is dead, and with the reopening exception, there's a wild card. And it seems to me we just have to read the statute now. It's not a question of notice, it's a question of timing.
So I agree with your honor. 2107C is jurisdictional. The Supreme Court said that in Bowles, but we don't think 2107C necessarily answers this question. What 2107C does is it lays out the procedures to reopen the appeal, and the district court complied with those procedures at JA 330 to 331. And so what we get from
But
21...
give me the short answer again, sir, just so I understand your position. So, but how does reopen not necessarily mean that the time that was before that, the window was closed? And so it could not be filed because the window was closed. You can only file when the window is open, right? And so reopen means, and for a specific period. I'm having trouble with the word reopen.
So once that period is reopened, the question is what has to happen going forward. And so because the district court granted the motion to reopen it, and because the notice of appeal was construed as a motion, but of course it was still a notice of appeal, we're then essentially in the situation of a plaintiff who filed a notice of appeal before the entry of judgment. It wasn't timely under the rules, but
So your position is it falls under 4A2? But the notice of appeal was definitely filed after the entry of judgment.
Correct, but we think that the situations are fairly analogous. In both events, you have a notice of appeal filed before the correct triggering event. Some intervening change happens, whether it's the entry of judgment or in here the reopening to appeal that now makes it timely. And that notice of appeal that was already granted, presented to the district court is then, there's no need to file a second notice. That original notice is now timely and properly before the court. If there's no further questions, thank you, Your Honor. We would ask that you reverse the district court's holding and remand this case.
Thank you so much. I note that you were court appointed, and I just want to say on behalf of the Fourth Circuit, thank you so much. We depend upon lawyers and students as well to help us with these cases. So thank you so much, and I might say that the Cavaliers were well acquitted today. And of course, Mr. Palmer, for your able representation of the United States here today. We're going to come down, Greek Council, and take a brief recess.
Can I just say one thing? Since we have a lot of observers here today, We had arguing in this last case, we had two students from the University of Virginia arguing, and I can say that their arguments were just superb. You were well prepared, and I'd like to recognize that on my own behalf. To let these observers know that you guys did a great job, very well prepared, and on a very complex issues.
All right, we'll come down.
This honorable court will take a brief recess.
seated. Ms. Newton?
Good morning, Your Honor.
Morning.
Good morning, Your Honors. My name is Deborah Newton, and I represent the appellant in this matter, Emilio Moran. May it please the court. I would like to reserve 7 minutes for rebuttal time. Your Honor, this appeal arises from the judgment of the District Court in the Eastern District of North Carolina pursuant to a guilty plea containing an appeal waiver to 2 counts of the United States criminal offense of sexual abuse of a minor and enticement of a minor for conduct occurring on Okinawa, Japan, while my client, Mr. Moran, was a civilian, court-martialed, ex-Marine residing in Japan with his family and in part of the indictment period, employed by a private company contracting with the Veterans Administration to provide separation counseling services. The issue I'm going to focus today's argument on is whether the record provided to the court in this matter to support the indictment allegations is sufficient, it provides sufficient factual basis to support or dispel the jurisdictional allegations contained in the indictment to which Mr. Moran pled guilty. We raised 4 issues below. At the conclusion of my remarks today, I will ask the court, 1, if the court determines that there are sufficient record facts to determine that Mr. Moran was not subject to the authority of 18 U.S.C. 3261 and 3267 as amended by Congress in 2004 to vacate the judgment and remand to the district court for dismissal with prejudice. Or, if the court determines that there is insufficient factual basis on this record to find that the Eastern District was authorized to enter this judgment against Emilio Moran regarding his status pursuant to 18 U.S.C. 3261 and 3267 to vacate the judgment and to remand for further proceedings. Your Honor, and 3, if the jurisdictional question is decided in favor of Moran, along with the errors raised, to also find that on a totality of the circumstances of this case, it is unlikely Mr. Moran would have entered into the plea with the appeal waiver, excuse me, and to rule against the government's motion seeking to enforce the waiver, and that's found at document entry 45. Your Honor, first I will discuss the employment prong. The statute that we are concerned with...
Can you start by helping me understand why our cases in like Carr and White don't just ultimately doom your claim? That this isn't a subject matter jurisdictional question, but it's a jurisdictional element question. And on the jurisdictional element issue, we've sort of said repeatedly that is an issue that's covered by a plea agreement, just like any other element of the offense. That the jurisdiction of the court is different, that this is the jurisdictional element of the offense, and like every other element of the offense, when you plead guilty, you give up the right to challenge the factual basis for it.
Well, Your Honor, what you're talking about is a conviction waiver with regard to the guilty plea. And with regard to the conviction waiver, you look to what the district court actually admonished Mr. Moran in the district court as to his guilty plea. Without a factual basis, the government absolutely made allegations in the indictment, and then at the district court made allegations with regard to an element of the offense, which Carr agrees is an element of the offense, that jurisdiction, because it is outside the corners of the United States, that the jurisdictional element is an element of the offense. The government made allegations at the factual basis, but did not support those allegations. So you were talking
Yeah, but he admitted to them. Your client admitted to them.
Well,
Right, so they made allegations, and he said, yes, those are true.
but there were allegations as to what the government would be able to prove, including whether Mr. Moran was employed by the armed services as the statute defines it in 18 U.S.C. 3261 and 67.
And your client said yes.
Yes, sir.
right? And so, just like the question of like, did he possess drugs, right? That the factual basis is on June the 7th, he possessed drugs. The client says yes. When we come up on appeal, we don't get to like then say, oh, no, now, how about appellate court? Will you look at the surveillance video? Because in the surveillance video, you can see that, like, that's just not what we do, right? And that's what it seems like to me Carr and White is telling us, is that where the allegation is made on a jurisdictional element like any other element, right? We don't review whether now on appeal the government can prove it up, right? Your client had the opportunity to make the government prove it up, right? It's called a trial, right? He chose not to do that, and that's obviously his authority. But what I'm having trouble with is why are we looking at this question any more than we would look at any other question in the context of whether the government can now, when you didn't raise it below, when your client agreed that it was met, we now like need to go sift through the documents to determine whether the government has already proven up like they would at trial.
Well, unfortunately, Your Honor, in this case, the government didn't prove up any of the jurisdictional facts. What they did was they alleged what they might be able to show at a trial, but not the specific facts.
Have you ever, how many times have you been at a plea hearing where the government proved all of the facts alleged for every element alleged?
Okay, I will.
No, they posit. They say, listen, if this case went to trial, we would prove that on May the 7th, Mr. Smith, possessed cocaine, and he got that cocaine from John, and he'd been getting that cocaine from John. That's not proof. That's the lawyer just standing there saying it. And then the client, the defendant, stands there and says, yes, they could prove that because that's true. Right?
Yes, that's right.
That's exactly what they did here.
It is not exactly what they did here. What they did here was the court read the allegations of the jurisdictional allegations into the record at the plea colloquy for the defendant, and then turned to the government and said, make your factual basis, which is in Your Honor's suggestion, when the government would have said, on February of 2018, Emilio Moran was employed by the United States military because he, but they did not do that. What the government did in this case was not make a factual basis showing at all on the jurisdictional element. It made a factual basis showing only on the sex acts with the 14-year-old child that he was accused of for the criminal offenses in the district court, and to which he pled. So it's different than in a drug deal if you say, did your client deal these drugs? Yes, because he pled guilty to dealing those drugs. In this case, the jurisdictional element is an additional burden of proof that the government must sustain, at least by making those allegations directly in front of the defendant, in front of the court, because we're looking at the court's state of mind here. And if those allegations as to the jurisdiction have not been made, we do not know what the court thinks the jurisdictional element is satisfied, and we don't know what the defendant is pleading guilty to with regard to that element, and the government never says, so the appellate court cannot review it. So in this matter...
So your argument is not that the district court lacked jurisdiction, right? Because that part goes away. Your argument is there was not an adequate factual basis provided.
Absolutely.
Okay.
Yes,
And so why is that outside this, even if it's true, why doesn't the appellate waiver bar that claim?
Okay. On the appellate waiver, what we're asking the court to do is, with regard to the sentencing issues, the appellate waiver does not affect this question because the parties, by their actions nor conduct, can waive the authority that Congress has allowed the government to prosecute this defendant. The parties cannot change that. So while,
The parties can't change an element of the offense either. I mean, the fact is, those facts were read in detail to this man, and he pled guilty to them, and the court went in detail about his waiver, saying as to all of those things, you're giving up your right to trial and review of those things.
yes, Your Honor, that's what the court did, but the court did not actually hear how the government came on the jurisdictional element, came within Congress's intent to reach someone in Mr.
Well, the
Moran's.
government alleged it in the indictment.
It's alleged in the alternative.
Well, so are the proposed facts alleged. In other words, the factual basis for, that the court gets is to satisfy the court that this guy's just not pleading into the air. But the scope of his plea governed all of those elements, and the waiver was told to him to govern all those elements.
Not, respectfully, not precisely, Your Honor, because when the factual basis is provided in court, it affects the court's state of mind for whether it's going to accept a guilty plea or reject a guilty plea. And in this case, Judge Dever did not have the benefit of any, not just a few, had the allegations in the indictment, but he had the benefit of no facts that allege that Emilio Moran came within the
What facts? How would he get those facts?
The government, just like the government did at great detail under the...
Well, that's a proposal of what it would prove. Those aren't facts either, are they? They're just allegations.
Well, Your Honor, I'll answer that question in this way. When the court turned to the government and said, give me the factual basis supporting the indictment, then the government placed in the Rule 11 hearing on the record the factual allegations, sorry, I was distracted that time, the factual allegations for this plea. The government proceeded to, at great length, describe the sex conduct with the child, as well as the enticement conduct with the child. When, where, and we certainly argue that those facts support us with regard to that he is outside, the base with regard to the record. But Judge Boyle never heard how Emilio Moran came within the status.
Well, let me ask you a hypothetical, and you'll probably answer this the same way, maybe. A man's charged with bank robbery. As you know, bank robbery is only authorized by Congress when the bank is insured by a federal agency. And so the indictment alleges all that, and the judge goes into it, and he says, I pled guilty to all of that. I robbed that bank, and the allegation is it was a national bank insured and so forth. And then they go and get the factual basis for the conviction, and they describe basically how he went in and robbed the bank, but they did not provide that the bank was nationally insured. That has already been alleged and conceded by the defendant. You say that's a defect?
I think that's different than what we have in the case today, because today, I'm a little confused by the 44 seconds here. May I finish my answer? Thank you, Your Honor. Because what we have here today with Mr. Moran is a statute passed by Congress in 2000 authorizing the government to prosecute citizens, U.S. citizens, who are acting as civilians outside the territory of the United States on a host nation who has jurisdiction otherwise over the criminal offenses.
Yeah, but Congress linked it up because he's employed by a national agency and all that stuff.
Exactly.
But that's an element of the offense, like the bank has to be insured. Congress basically exercises jurisdiction of its own civilians, employees of its Defense Department, and VA in this case. But all right, I'm not sure I understand how that's different from the national bank hypothetical, but
So may I?
Please.
The difference is that Congress specifically in 2000 passed the Military Extraterritorial Jurisdiction Act in response to a specific issue with regard to civilian contractors employed by federal, or by, at that time, simply the DOD, people acting on behalf of the Department of Defense. Congress amended the statute in 2004 in specific response to the Abu Ghraib atrocities in Iraq with federal agency subcontractor employees acting as
Well, let me ask you this. If you're right, and we assume you're,
And he was not.
you're correct on this, what are you arguing now? That leaves us with the opportunity to decide whether he met Congress's hook?
That's correct.
And what are we going to base those facts on?
Those facts are going to be based on,
The allegations of the indictment, right?
well, the allegations in the indictment, and I think the government has a very well-placed point when it says the court can look to the entire record. When you do look to the entire record, which Judge
But why wouldn't the
Shepard-
record also include your client's admission, right? It's like a guilty plea is like a confession, right? And so he has confessed in open court, under oath, right? Like no questions about improper interrogation, right? We got it on the record. Like he confesses to it.
You have to look at what the court admonished him of and what he actually confessed to. He confessed,
Committing the crime.
He confessed to the sex acts, the sex with a minor. and
Actually, the court spent a lot of time reading the introductory stuff and explained, went to him, and then when it came to each count, said, I'm incorporating what I've already read to you. But the court read all the introductions as to his role as a civilian working for this agency and so forth.
And the problem with that, Your Honor, is that those allegations in the indictment did not provide facts for the factual basis, and the government, at no point during this case, in the entire record, actually alleged whether Mr. Moran was still a military employee, although in the record it is revealed that
Well, the fact is his confession. The question is whether the court alleged it, and I think the court read the whole thing, including his employer, his circumstances, where he is on Okinawa, and all this stuff. It was alleged, wasn't it?
So it was, the court alleged that Mr. Moran was an employee pursuant to the statute, but it also alleged that he committed these sex acts and the enticement of the minor, as well as all the other 5 counts in the indictment. But when the court turns to the government for the factual basis.
Well, I understand that argument, but I thought we were beyond that. You were saying if you look at the whole record, what do we look at? And we have these allegations that he worked for the VA Transition Assistance Program at the Air Base in Okinawa, the federal agency, and all. It goes down the whole list of his relationship and his job. And so he admitted to all those facts.
And that's why we asked for, in our brief, a de novo review on the first issue that I raised, because if the court engages in an interpretation
Well, no, let's accept these facts. So what would your argument be? You say these facts are inadequate?
They were allegations, and we
Let's accept them as facts, the alleged facts.
No, they were not accepted as facts. They were allegations.
I understand, but I'm saying assume they are facts.
They are not
Are they sufficient?
They are not sufficient and not true. But either way, we don't have a full record. If the court, I'll say it this way, respectfully. It is error, Rule 11 error, for the court not to receive a sufficient factual basis on the jurisdictional element, which is an element of the offense under this statute.
So what is the relief you want? What is the relief you want?
The relief, if the court finds that there is sufficient.
No, we find everything you're alleging. What relief do you want?
We would ask if the court finds that Emilio Moran was not employed and not within the statute, that the case get remanded for an instruction to dismiss with prejudice. If the court finds that there's insufficient factual basis.
So your suggestion is that basically the allegations of the indictment, if proved to be true, are insufficient to satisfy Congress's hook.
Only on the jurisdictional element with regard to the status of Emilio Moran when he acted as a civilian outside the United States for a contractor for whom he did not work in support of a mission of the DOD, which is something I think the government's going to talk to you
Well,
about.
it says, I think its language is related to the militia,
Related to the mission
which is a
of
pretty
the
broad
DoD.
term, that related.
That's exactly right. And the Supreme Court has not decided what that language means. And in the U.S. v. Slatton case, I believe the government.
Well, I want to just get to the bottom line. You're basically saying then the indictment, even if proved true, every element of the indictment is proved true, that the government has not stated an offense, sufficient offense, and we should remand it for dismissal.
No, sir. What I'm saying is there is an insufficient record supporting the jurisdiction.
I understand, but I'd like to get you to talk about whether the indictment alleged sufficient facts.
No, the indictment did not.
Okay,
allege-
that's what I thought your position was.
Yes, sir.
And which allegation was insufficient?
On the element of whether Mr. Moran under 3267-1A32 and B and C, 3267-1B and 3267-C, whether he was employed by a federal contractor or a sub-tier in relation to a mission of the DOD that we would contend that he was not, whether he was a dependent of a member of the DOD, and that wasn't federal agency, that was a member of the DOD or a subcontractor, or ordinarily resident in the country, and he was in fact ordinarily resident in the country as of 2012 with his family. So because he wasn't confronted with those facts in court, his plea was invalid, and because the court did not hear those facts that supported the allegations in the indictment, the court's state of mind is called into question. No, the Judge Dever never said, which is it? Or how do you know that? Is he an employee of the military? How so? And how does that support the mission of the DOD? Or, okay, is he a dependent of a...
So the defendant stands up and I said, I agree to those allegations. You don't need to demonstrate that. And Judge, go ahead and sentence me. I plead guilty.
Your Honor, I think that...
I've probably pressed this question. I see your time. I didn't want to drag it on, but...
Mr. Bragdon?
Thank you, Your Honor. Good morning. May it please the court. I'm David Bragdon, and I represent the United States. I wanted to start out with looking at what I see as the standard for a factual basis, and the standard which comes from Carr, it's in a footnote there, it's in other Fourth Circuit cases as well, is whether the district court has assured itself that the conduct the defendant is admitting is an offense under the statute that he's charged with. And I think that that is satisfied here by the defendant's admission. And in Carr, one of the problems in Carr was that the court had not phrased its question very well to the defendant. And so it had asked a question along the lines of, did you commit this offense? And it mentioned the interstate commerce component, but it also mentioned, did he knowingly set fire? And when it finishes all that, it says, did you do that? And what the court said is, it's unclear in the circumstances of that case what was meant by that question. Did it mean that, did the defendant set fire? Did it mean something broader than that? We don't know what it means. And so we're gonna send it back for another Rule 11 to allow the court to do the factual basis part over again. I think the difference here, and I wrote down the language the court used, is, it reads all this jurisdictional, it reads all of the language that constitutes these specific facts that set forth the element, and then it says to the defendant, did you commit the crime charged in count 2? And I would argue that's just a different question. It's a broad question. And when the defendant says yes, he's admitting to the things that the court identifies.
He's admitting to committing the crime. This case is different. It's jurisdictional. I mean, normally, you don't prosecute cases that occur completely in another country, right? Forget about whether you did the crime or not. You could do the most heinous crime there is. But if you did it in Japan, the United States can say, well, we're going to prosecute that in the United States. But there is a statute that allows that jurisdiction. That's separate from the question that you commit the crime. The question is whether or not you have the authority to reach all over, to Japan because of this. And you can when you're working for DOD, carrying out the mission of the Department of Defense. That's very jurisdictional. It's not about just the crime. And that was not laid out, but even more so, more importantly, under Beasley, that's not, if it's jurisdictional matters aren't waived. And you can, notwithstanding a guilty plea. Is that right? How do you read Beasley there?
So respectfully, Your Honor, I think there's a distinction between subject matter jurisdiction, which is not waivable and which deprives the court of power to hear the offense, and an element of the offense that provides jurisdiction. And I'm sure someone smarter than me could explain those differences better, but I think that
I know the difference. Make your argument.
Something like interstate commerce, something like supporting the mission of the Department of Defense, those are elements of the offense. And so what happened here is, the question here is whether the defendant whether there was adequate information for all the elements of the offense. I think Carr is clear that this court was not deprived of jurisdiction, of subject matter jurisdiction, nor the district court, because the indictment is very clear in alleging the components of the crime. The defendant admits to that, and so what we have is just a question of whether or not this element is adequately shown. It's not.
Okay, and what is the element? You call it an element. What is it?
The element is that the government must show, and let me, if the court will give me a second, I would like to get the language correct here. So the court must show that the defendant, that the government must show, and the court must be satisfied that the defendant was employed by or accompanying the armed forces outside the United States. That's the element.
When?
During the time of the crime.
Okay. And when do you say he was told, he admitted to a fact of that, being employed at the time of the offense?
Well,
for 18 months he wasn't employed, right? He was unemployed, and the other time he was a sexton at a church, I believe it was.
So the
Tell me the time frame, that 18-month period, that he agreed that during that period of time that he fell within that or not otherwise being resident. Because there's a difference between someone being, in terms of in the country, they get the job, they're in the country because they have the job, as opposed to they got the job because they're in the country. That's a distinction. So it's a very complicated thing in terms of you tell me what facts that were read to him that he agreed to in that sense, in that time period, that 18-month period, concomitant with the offense.
Well, and let me be clear, Your Honor. I believe.
I want you to be clear when answering my question.
I will.
Okay.
I believe. Let me correct one thing before I answer the question. I believe the crime was over a 6-month period, not an 18-month period.
No, I'm not. I'm talking about for 18 months period, he wasn't employed by anybody except for the church for a period of time. It has to be It has to be during the time that he is actually under the jurisdiction of a job or dependent in terms of carrying out the DOD's mission. What period did he say that I committed? When I committed this, I was so employed. Because that's the hook for the jurist, as you call it, an element. I'll let y'all conceding you call it an element. That's the element in terms of facts that he knowingly pled. Because otherwise, we fall into car and not being clear about that. So tell me that.
Well, let me step back for 1 second, and I will answer the question. But I want to say that we believe that it was shown in two different ways, both in his role as a dependent and also in his role as a contractor. And to discuss the contractor part, on plain error review, the court can consider the whole record. The record shows that he began his employment as a contractor on March 3rd. The time period of the crime began a little bit before that. It began, I believe, if I can get the...
February 19th.
February 19th. The first time of intercourse would have been sometime between February 26th and March 5th. Over this period, you have March, April, May, sex 3 times a week with the victim. You have various things, and related to the count charging enticement and the use of devices, he's providing her that phone.
Wait a minute, is employment alone enough to do it? If you're a foreign citizen? Go ahead, is that enough?
Employment alone, based on a contractor, is not enough. As I understand the elements, it's got to be a contractor working for an agency and supporting the mission of the Department of Defense. And the defendant...
What? What about residency?
The defendant must be residing there in connection with, which I think is a broad language, but in connection with the position. And then third, you must not be ordinarily resident. So to me, those are the elements. With respect to his dependent status, it's also 3 elements. He's got to be a dependent. He's got to be residing with the person who's supporting him, and he has to be not ordinarily resident. So the last element overlaps between those 2 theories. The court read to the defendant both of these theories, both the dependent theory and the contractor theory, and
he read a theory to them during the plea?
What's that?
He read the theory to them?
He read the allegations. He read that this is what, and this part is what I would consider a speaking indictment. The government in the indictment just it alleged facts. It didn't allege just the bare jurisdictional components. It alleged facts here.
Well, it's the Rule 11 colloquy we're looking for, right?
The court then...
Isn't it the Rule 11 colloquy that we're trying to get to?
Well,
they're not even understanding, because a lot of people don't understand indictments.
Well, the reason the indictment is relevant is because the court takes those same facts that are alleged in the indictment, and it tells the defendant about them in the Rule 11 hearing. And when the defendant admits he committed that offense, it's incorporated.
Now you ready to answer my question? What fact related to that was told to him in Rule 11 that he admitted to?
Okay. The court specifically asked...
You're reading from the transcript, right? You read the JA?
I will pull it up.
I'm just long as I'll take your word from it, but I'll make sure you're reading from the JA, right? Okay, go ahead.
So starting at page 34 of the JA, the court says that the defendant was a civilian employee of the VA Transition Assistance Program located on Kadena Air Base, Okinawa, Japan, a federal agency that supports the mission of the Department of Defense. The defendant was present and residing outside the United States in Japan in connection with such employment. The defendant was a civilian employee of the Department of Defense located on the base at Okinawa. Then regarding his status as a dependent. The defendant was residing with such civilian employee outside the United States. The defendant is not a national or ordinarily a resident in Japan. And so the court then incorporates that into its discussion of the offense, and the defendant says, in answer to the question, did you commit the offense charged? The defendant says, yes, sir. And the court follows up and says, so you are in fact guilty of that count? And the defendant says, yes. And so the defendant had the facts relating to all of these elements in front of him, and admitted that he had committed those offenses.
Well, in terms of, he said, he admitted that he was not ordinarily a resident.
Yes, Your Honor.
Well, so you're saying that if you get a job on March the 3rd with the DOD agency, you could have been in Japan for 20 years and all of a sudden now you're not ordinarily a resident of Japan? Just because you got a job on March the 3rd with DOD?
I'm not saying that, Your Honor.
I didn't think so, right. So how do we skip then from that period, the 18 months, having established, once he's separated from the United States Marine Corps, he's just an American in Japan. Matter of fact, not working. So when he's there, he's a resident of Japan for about a year and a half. So all of a sudden you say, because he said, I had a job on March the 3rd, then you backdate that to say, oh, that means that everything you did in 18 months, you're not ordinarily a resident. You are. I mean, he was there for 18 months, not employed by anybody.
He also admitted he was a dependent, and that he
Can I ask, I don't know whether I don't know the record maybe well enough, but was there evidence that he was an actual resident of Japan? Was his immigration status such that he was a resident of Japan?
Your Honor, that's not in the record one way or the other. And what I would say to take...
But the allegation was that he was not an ordinary resident of Japan.
That's right.
And that's what he admitted to.
And that's what I would say is, I would say at a Rule 11 where the defendant is pleading guilty, it's enough for the defendant to admit I was not ordinarily resident. The government, the court, the district court is not required to draw out a whole bunch of factual details in the absence of any suggestion that would call that into question. And I think the fact that if you look at how much the defendant was making in...
Do you know what it requires to be a resident of Japan? I mean, I'm just trying to figure out how we would possibly answer this question. But like, I mean, do we go to like the Department of State to figure out what residency in Japan requires?
I would imagine you could look at the Department of State and you could look at... I have talked to some people in the military who have that background, but that's not in the record, and so I don't want to answer that.
However you do it, Congress did say it's part of what's required.
What's that, Your Honor?
Congress it was in the language, the statute.
Absolutely, and if you look at the language, it says not a national or ordinarily resident, and so I think the idea is they did not want this statute to be prosecuting, Japanese citizens in Japan or other citizens who may have had some role or some work with the U.S. government. They wanted to limit that. They probably did not want it to cover maybe, an American who had married a Japanese person over there who'd lived, who perhaps obtained U.S. citizenship but was staying there long term. I mean, I think there's exceptions, but when the defendant admits that he's not ordinarily resident as part of his plea, I think that component is satisfied. And I will say, I'd like to just say with respect to his employment as a janitor, making $10 an hour, the PSR shows no Social Security withholdings for 2017. And we don't know if that job is full-time or part-time. But I think it's a big leap to say that just because he was a janitor for a period of time between his end of his time in the service and his beginning of the time as a contractor, that somehow he was ordinarily resident in Japan just because of that. And So I would say the more logical conclusion is what he admitted and said at the Rule 11 hearing. If there's no further questions from the court, I would ask the court to affirm. I believe that there is a sufficient factual basis here, and thank you for your time.
Thank you, Mr. Bragdon.
Yes, thank you, Your Honor. Judge Richardson, going to your question with regard to residency, the government has just said that there was no U.S. Social Security taking during those 18 months between the time, in the U.S., between the time that Emilio Moran was court-martialed, discharged from the military in 2016, thrown in the brig for 90 days, I believe it was, unemployed, and then began work in 2016 August at the Marantha Baptist Church there in Okinawa, Japan, which is not on the base, not any way related to the base, where at that private school related on those church grounds, apparently, according to the record, is where Mr. Moran met the girl at question here and her family and became very intricately involved with them. So for that entire period of time, the United States certainly wasn't taking Social Security withholdings from Emilio Moran. And your question was as to residency, what's required in Japan. So with regard to that question, again, none of this is in the record. That's why we're having some
You know, the difficulty with this whole argument is we're retrying the case. And the whole purpose of a guilty plea is to void the trial. And the only thing we do as a matter of fairness is we want to advise the defendant of what he's pleading guilty to and have a factual basis for the crime. And so that he doesn't plead to some crime he didn't intend to plead to. But he clearly intended to plead to this crime and admitted all the elements. And so he admitted I was not a resident, a regular, ordinary resident. He admitted that he worked for the agency. He admitted to all the facts relating to the woman. He admitted to his dependency status. And the question is, shouldn't that end it? That's the whole purpose of the guilty plea. And now we're trying to undo the guilty plea. I thought it was very, very thorough, the whole explanation. He was read everything. He was asked in detail about his waiver of appeal rights, and he said, I pled guilty without hesitation. So now we want to retry it. That's what I'm hearing.
No, Your Honor, we want to try it in the first instance on this jurisdictional issue. If Emilio Moran, or if the parties cannot waive jurisdiction,
That is only subject matter jurisdiction. That goes to the power of a court. This has nothing to do with it. This is an element of the offense which gives Congress the authority to legislate.
Exactly.
And the court has made clear again and again that this is an element of the offense and can be waived.
This particular element of the offense was crafted by Congress outside the reaches of the United States in order to give the United States certain delineated powers.
Outside the reach, it's with the armed forces. We have armed forces all over the world.
But
And
it
if you
wasn't
commit, and just to take a hypothetical, if you commit a sex offense on a base and one military against another, you have no question that that's American jurisdiction. Okay, so Congress here defined the jurisdiction to be if you're on the military, if you support the military, you serve the mission, you're a contractor, you're dependent of a contractor. They've linked it all together. Now, if you want to challenge the statute, then that's a whole different thing, which you haven't done. What you're basically arguing is that there wasn't a factual basis for this jurisdictional hook, this connection to the military.
Correct, because of Emilio
But we're not
Moran.
challenging the statute, right?
We're not challenging.
Okay, so
the
he admitted to the elements of the statute.
He admitted to the elements of enticement of a minor that he pled guilty to, and he admitted
He also said, I'm not a citizen. I lived in there. I was an employee of the Veterans Administration Transitional Agency, and he had all of those things he admitted to.
Well, if you actually look at the transcript.
I've looked at it several times,
Of
yeah.
course you did. Your Honor, no offense intended. But when you look at the colloquy, Judge Dever read the allegations of the indictment that were not fact-specific to satisfy the carving out, if you will, that Congress did in 18 U.S.C. 3267. Without those specific facts, he read simply the allegations and then said, did you do this? Later, I'm not going to reread it, but did you do this? Sex acts.
He said, these are the allegations of what they're charging you, and he explained them all, including his employment, including his citizenship, including where he's a resident, including his job, and all of that. And then he repeated when he went to each specific offense, he says, I'm incorporating that into this. And then he says, how do you plead to that offense? And he says, I'm guilty.
Your Honor, in the context of the transcript, the judge read the allegations. He turned to the government for the factual basis.
No, he didn't. No, he didn't. He pled the allegations, asked him, do you plead guilty? He says, yes. And then he went to the government and said, I need a factual basis.
To support the allegations in the indictment. And the allegations in the indictment that were not supported by 18
Well, now your argument's a little different, that whether he pled guilty to the facts. That was my initial inquiry. Now you're going back to the questions whether the factual basis that the government gave was sufficient.
It's not supported. It is Rule 11 with regard, if you look at it that way. So with regard to the statute, it required under the employed as in 18 U.S.C. 3267(1)(a), it goes down to 3, an employee of a contractor or subcontractor of any tier, down to 2, of any other federal agency or provisional authority, to the extent such employment relates to supporting the mission of the Department of Defense overseas. That is the limitation carved out in the 2004 amendment to the major statute by Congress in response to the Abu Ghraib private contractors issue.
Then why didn't you move to dismiss the indictment if you don't think it was sufficient?
Well, I mean, I always hate to say this, but I did not represent the defendant below. I did inquire, and that's not in the record.
Can I ask you just one final question, because I know you're out of time?
I am. Thank you.
When would you have us, or do you have some precedent for us that I could look at for the idea that we cannot rely on a defendant's admissions to establish the factual basis? I mean, that's often, at least the case law that I recall as I think about it, we say you can rely on the statements of the government lawyer, right? It's just statements, right? He's just standing up and saying it, right? And you can rely on the admissions of the defendant, right? Those are the two things. And then occasionally we say, if there's a PSR already prepared, you might be relying on that, but that's not here. But the two things that we talk about as permitting us to establish a factual basis are both the admissions and the sort of offer of proof, if you would, not actual, there are no facts, right? There's just like an allegation being said by the AUSA, typically, sometimes the agent. When would you have us say that we cannot rely on a defendant's admission? What's the principle there?
When the facts are not specific to the carved out status of the defendant in the indictment, and that is the problem here. I'm out of time, may I have?
No, but with the chief's indulgence, I think we'll be okay. But that's just saying, you should make you should not rely on a defendant's admissions in my case, right? Which is not a rule, right? That's just saying don't apply this general principle to me. But we have all these cases that say we can rely on a defendant's admissions in order to establish the factual basis.
Thank you. And in this case, the defendant was not confronted with factual allegations, a factual basis supporting one element of each of the offenses, meaning the jurisdictional element, because the government, before it launched into all the sex acts, it never said how immediate...
No, I understand that, but that's what the government's lawyer was doing, right? But before the government's lawyer talked, your client admitted that he committed the crime charged in count 2, right? And so what I just want to understand, and I know we're over time and I'll let you go, but what I'm trying to understand is why in this case, as opposed to every other case we have, do we ignore the defendant's admissions? I understand you think the defendant's admissions aren't sufficient, but bracket that for me if you would. I'm not asking for a concession on that. But why should I ignore whatever the defendant's admissions are? For example, the allegation was he worked for this particular company, right? And so did they have to like literally put on proof that he worked for that company when he admits to having done that?
Yes, Your Honor, under this statute. And the reason
But this statute only, this is sort of like a one-ticket ride.
Well, this is the only statute that I'm addressing with regard to this case. And this statute has to do with prosecuting by the United States criminal offenses by citizens of the United States who reside in a foreign country who have jurisdiction
So
over
your rule is just for this case? Because in a normal case, like you wouldn't have to do that. But your point is here you do.
And I'm saying that he was not confronted with the facts that Congress specifically requires to allow the United States to prosecute individuals outside the United States under these circumstances. Because Emilio Moran, as recognized in some of the questioning from the bench, from the chief, was not a member of the United States military, having been notoriously court-martialed and jailed. He was employed as a private citizen in the prefecture of Okinawa.
Can I ask one other question, Chief? I'm sorry.
Sure, go ahead.
So, total hypothetical question. This is not your case, obviously. But imagine the scenario where a judge says, in a 922G case, Mr. Defendant, you've been charged with possessing this, Glock 45 caliber pistol on March the 7th of 2012, and that firearm traveled in interstate commerce. Do you admit to that? And he says yes. Is that sufficient, right? I mean, is that enough of a factual basis for a 922G charge?
So that is a within the United States prosecution, but it's within, and of course, the jurisdiction of the United States is except for the jurisdiction of the individual states. So that allegation.
But that would be sufficient in your view. But I understand that you think it's different, but in your view, that's sufficient because he's alleged that, the firearm traveled in interstate commerce and that he possessed it on this date, and the defendant says, yes, I committed that crime.
So it's not in your hypothetical only. It's not outside of the realm of belief for the court's state of mind that a weapon would have been, for example, produced in one state and traveled through interstate commerce to be sold in the state where the crime is being committed. And it's not unreasonable to believe that the defendant knows that fact. However, in this case,
He's pleading guilty. This is not a mini trial. He's coming and saying, I want to avoid a trial. I'm going to throw myself in the mercy of the court. I did the crime. I possessed a gun that traveled in interstate commerce. And the judge says, was this the weapon? Yes. Okay, I accept your plea. Now, do you saying the judge has to reasonably believe whether that gun went in interstate commerce?
yes, it is a Rule 11 requirement that the court
He has to have an independent factual basis to make sure that the guy's pleading guilty to the crime that's actually involved.
Exactly.
Right.
Because we do not.
But that doesn't mean you have to cover every corner and nook of the evidence. What it basically means is you have to be satisfied that there's a factual basis for the crime committed.
And I believe Judge Deborah was satisfied that the sex acts occurred and the enticement occurred. But Judge Deborah was never advised how Emilio Moran came within the jurisdiction or the authority granted in the specific limiting language by Congress.
He says to you, he says to Moran, he says it alleges here that you were a citizen of the United States and you worked in Japan for this defense contractor. Do you admit to that? Yes. Is that enough?
No, because the statute as amended requires more. It requires that the contractor,
You missed my point. My point was the fact that he admitted it. I mean, You know what there was alleged.
He
It's
admitted
page
it.
34 and
Yes, sir.
35 of this complaint. It's all laid out.
It is the court's gatekeeping function to ensure that Congress's intent in passing a statute is satisfied. And if Congress did not describe an individual who should be before the court, even though he pled to it, that is the court's gatekeeping function. And in that way, the court is fully authorized to inquire to satisfy itself. The court did not do that in this case. Did not ask any questions. Well, which is it? I could hear another judge in our district saying, was he employed or was he a civilian dependent or was he both? And how is he ordinarily resident or a resident, like the indictment says? But he was not even ordinarily resident, and the court didn't inquire because the record clearly establishes by sentencing, at least in the PSR, that Emilio Moran was kicked out of the military in 2016, and the offense conduct began allegedly in February through October when he, according to the government and the PSR facts, fled Japan because of this investigation. The investigators, the Air Force investigators, according to what's in the statute, never even contacted Okinawa, Japan authorities. They immediately started their investigation in August. They had from August to October, when Emilio Moran fled Japan because of the investigation, according to the allegations, to notify the prefecture of the criminal conduct in its borders, and they did not. They immediately began investigating him for several months before he left. So that goes to whether he was resident, of course. It also goes to the fact that the government didn't feel like it needed to prove and didn't investigate the facts sufficient to demonstrate to the district court that it had jurisdiction over this case. It assumed it. And the district court had the duty to inquire and did not. So, Your Honor, may I conclude?
Yes, you may conclude.
If this court finds that the whole record is sufficient to find that Emilio Moran was not either an employee qualifying under the statute or a dependent under the statute and was ordinarily resident in Japan at the time of the offense conduct, we're asking that you vacate the judgment and remand for prejudicial dismissal. If the court finds that the Rule 11 was insufficient and that there was insufficient factual basis to support the element of the offense on jurisdiction, that you remand back to the district court for further proceedings, which could include a number of things based on the, obviously, discussion, and that you deny the government's motion to dismiss with regard to the appeal waiver. If there are no further questions, my time is well over.
Yeah, thank you, Ms. Newton.
Thank you.
Mr. Newton. I know that you are court appointed, and on behalf of the Fourth Circuit, I want to thank you for accepting the appointment. We depend on lawyers like yourselves to come and argue these cases and help us in these matters. We appreciate it. Mr. Bragdon, your able representation of the United States as well. We'll come down to Greek Council and proceed to our final case for the, I guess, I started morning, but for the afternoon. Ms. Koenig?
Thank you, Your Honor. May it please the court, I'm Assistant Federal Public Defender Laura Koenig, and I represent Appellant Troy Skinner. There are 3 issues on appeal in this case, and today, with my limited time, I plan to focus on the first issue and rest on the briefs on the remaining issues absent the court's questions. As it relates to the first issue, the district court should have granted Mr. Skinner's motions to dismiss counts 1 through 9 of the superseding indictment, which were the production of child pornography counts. The production aspect of the visual depiction at issue here happened entirely in New Zealand. And 18 United States Code Section 2251A does not apply extraterritorially, and on the facts of this case, it has no domestic application here. The district court thus erred, and this court must vacate Mr. Skinner's conviction on count 1.
Can I ask you as a preliminary question, and maybe lead into another question? If a man stands in Canada with a rifle and he shoots across the boundary into Vermont and kills a farmer who he's angry at, can Vermont prosecute that man for murder?
And I think that leads to the analysis that this court has to do.
Well, I just want to, under that hypothetical, has he committed murder in Vermont?
It would depend on the language of the statute, Your Honor.
Just common law?
If it was just common law, perhaps so, but we're not proceeding under common law
I
here.
understand that, but obviously the elements of my hypothetical are that the perpetrator is in Canada and the victim is in the United States.
Yes.
And is killed in the United States by a bullet that was launched from Canada.
Yes.
Okay, go ahead. I think that might be analogous here, but.
Thank you, Your Honor. And I can appreciate the court's analogy, but we have to follow the steps that the Supreme Court has laid out for us.
No, you take it through.
And so the first step is we have to look to the language of the statute to decide or determine whether or not Congress clearly provided for extraterritorial application in 18 United States Code 2251A. Congress has been very clear that just simply general references to foreign commerce or any person, those are insufficient to trigger a finding that there is a clear intent to apply a statute to extraterritorial conduct. RJR Nabisco was clear to say, it's not enough to think about what Congress would have wanted if the facts had been presented to the court at that, or to the Congress at that time. But what we have to look at is whether Congress has affirmatively and unmistakably instructed that the statute will do so. Here, what we have are general references to foreign commerce, and as this court and other courts, including the Supreme Court, have found, that is not sufficient to trigger a finding that there was a clear intent to apply the law extraterritorially. So if that's the case, and if in fact there is conduct that happens outside of the United States, then we have to turn to step 2, which is to determine whether or not there is a domestic application here. And in doing that, the court has to determine what is the focus of the statute that we're proceeding under.
Would you agree that all of these pornography statutes are intended to protect minors and the abuse of minors?
So that is the general structure of the act, yes, Your Honor.
And this young lady, 13-year-old girl, was in Virginia the entire time the offenses were committed.
She was, Your Honor. And so when we look at this court's precedents in talking about what really is the heart of 18 U.S.C. 2251A, we look at Macaulay and we look at Palomino Coronado, which talk about the purpose of the statute at issue in 2251A is the production element. Other statutes, whether they're state or federal, cover the sexual activity or the abuse that would have been put upon the child. But the focus of this particular statute is the production, the creation of the visual depiction, the preservation.
Well, that's obviously necessary to bring a defendant in. It was also necessary that the man in Canada pull the trigger. That was the production of the thing. The question is, what was the target of the crime, who was being protected by the crime, and where was that person injured?
Well,
and in this case, the child was totally in Virginia, was injured in Virginia. The pictures were taken of her while she's in Virginia, and then they were put on the internet or wherever they went.
And I hear the court, and obviously the Child Protection Act is designed to protect children. That's a given. But what we're looking at is this particular statute, as opposed to, say, 2422 or possession of child pornography. There are other statutes that may cover other aspects of this case, or that could have covered other aspects of this case, but the government chose to proceed under 2251A. And when we're looking at what makes that a crime, we're focused on the defendant's actions of using, enticing, persuading, those verbs, as well as the production of the child pornography itself. When I think of 2251A, I think of sexual activity plus. It's got to be the sexual activity, which is the harm to the victim, but plus the elements that make this a crime here.
All right, so, but help me understand, so if, hypothetically, if I accepted your idea that the sort of focus here is production, why and maybe it's different in the sort of the old analog world, but why in a digital world wouldn't we think about the production of a depiction when it's being done by video chat on a computer system, like a wire? It's being done on both ends, right? That like you're not producing a depiction without both the camera on one side and a recorder on the other side to oversimplify, you know, the mass series of tubes that happen in between, right?
Yes, Your Honor.
So if you're right that it's production and not sort of focused on the victim, why do I think that this doesn't look like the sort of interstate wire cases or foreign wire cases where we sort of say, yes, but there's conduct on both ends?
Yes, Your Honor, and I think that there is the way that I am asking the court to think about this is when we look at the indictment, the superseding indictment charged in this case, the creation of the files, the images, the video images, the digital images.
The indictment definitely has to focus on the defendant's conduct because that's what a crime is.
Yes.
Right, but we look not at just that, right? We're
Right.
looking at what the focus of the statute is. It's a different question than what the indictment
Right.
charges, right? And so we look at the focus, and you've suggested to us, and there are lots of options, but you've suggested it's production.
Yes.
Or also transmission, right? Because it's production or transmission if we're looking at the statute, but let's stay on production. And the question is, where's the conduct that relates to that focus? And to say that the production of this is only at the receiving end of the internet and not at the start end of the internet seems to me to miss the idea of how the internet works.
And I appreciate that, Your Honor, and I think if the government had charged this under a theory that the live transmission was the specific conduct that violated the crime, perhaps that would be a question that I would need to spend more time with Your Honor on.
Well, this one's even clearer because the statute says all those verbs, uses, persuades, induces, entices any minor to engage in sexual conduct, that type of thing, with the intent that such minor engage in sexually explicit conduct for the purposes of pornography, of
Yes.
producing photographs. So in this case, it has to entice the minor and persuade the minor to engage in sexual conduct for the purpose of being photographed.
Yes, Your Honor,
And all of that took place in Virginia, right?
but it is all a but-for. Every time we have a case in which there is some conduct that happens in the United States and there is some conduct that happens extraterritorially, there will always be a but-for causation problem, essentially, because but for the two knowing each other, there would not have been this issue. But for the fact that the computers existed on both ends, there would not be the issue. And what we think we have to focus on is here, the government charged this as a production of tangible recordings. That is how this case was charged. That conduct, that recording, the decision to hit record on the Discord chat and to make a preserved copy of their conversation, that happened in New Zealand.
But couldn't have happened and that's the same thing with a wire, right? You say, like, the decision to receive the wire, right, only happens on one end. But our case law, I think, is pretty clear that when we look at a wire, it's both ends, right? Because without one end, you don't have the other. And it's true, you can send a wire that's never received. All right, well, that probably means the end doesn't work. And if this was a live, a video that was sent and he had his computer off, right? Okay, I understand that. But where you've got two ends, right? What they're alleged here is that is to do all these things, to wit, a video with this file name, right? But how was that produced? Like, it takes two to tango, right? I mean, in this depiction context, to produce this depiction, right, it can't happen with just one.
It absolutely takes two to tango, Your Honor, and that's what, so if we think about a hypothetical in which the minor, let's say, was on a military base in New Zealand, right? I'm not sure of all the legal ramifications, and I don't want to...
Don't complicate this any more than you have to.
But let's imagine that there was some basis where the two of them are in the same room. That conduct between him observing her is what I am submitting to the court is what happens in Virginia, the observation. But it is the creation in this case as it was charged. Had the government operated under a theory of live transmission that was what the criminal conduct was here, we might be having a different discussion. But because they charged the creation of the video.
The creation had to be in Virginia. The camera, the transmission of a real person onto some film or text or digital data occurred in her room in Virginia.
And Your Honor, that is in order to facilitate the communication, yes, but there's nothing in the record that indicates that there was something that was...
But it's her camera on her device that that took the picture.
Yes, Your Honor, but there's nothing that indicates in the record at all that there was a preserved copy on her hard drive or anything like that.
No, it was clearly pulled up into the internet then, and it's all over wherever he transmitted it. But the fact is you are focusing on the word production so heavily and ignoring her and her conduct and necessities of her being complicit or yielding to the persuasion and actually taking the picture of herself. She has the camera in front of her, and he's at the other end watching.
And again, Your Honor, I submit to the court that if this case had been charged under the live transmission theory...
So can I just ask you about that, right?
Yes, Your
because
Honor.
the indictment charges live transmission too,
As an
right? And so
alternative.
help me understand, because where it says, and for the purpose of transmitting a live visual depiction.
And then it says, to wit, at the end of each count, specifically the creation of a preserved video or image file. And so that's where I think...
But it's both, right? That's evidence of a live transmission, given the facts here, and it's evidence of the production of a physical copy. So that file, that to wit is not a limitation on the indictment language, right? The to wit is to say, like, which count are we talking about? What are we talking about? This one. What do we know about that? This was a recorded version of a live transmission. So it's both production and live transmission. I'm not sure that this makes a lick of difference, right? But I don't understand your argument that the indictment is limited to production. It is production and live transmission, because we know in this case that he recorded the live transmission. So the file is both a depiction but evidence of a live transmission.
It is the evidence of a live transmission, Your Honor, but it is the production of that recording that is the conduct that was criminalized in this case. And that's my position on that issue. I think that...
If you're wrong about that, do you concede you lose?
I may, Your Honor. And so one other thing that I want to bring to this court's attention is that the government has cited the Harris case in talking about that this court could skip over essentially the first step of deciding whether or not this case, the court has to decide the first issue of whether the statute applies extraterritorially, and that is not the case. This court must proceed as the Supreme Court has directed through step one to decide whether or not there is a clear indication that it applies extraterritorially before getting to the domestic application.
Why is that again?
Harris relies on Morrison, and it's a oblique reference essentially in Morrison, but Harrison talks about when you have a special case essentially, right, that the analysis of the first step would be so complicated and overbroad that this court doesn't want to wade into the morass where there's a clear domestic application. We don't have those facts here. In Harris, the case...
No, but you just said we have to. And that's what I didn't understand, right? Like, I mean, if we found there was a domestic application, it just doesn't matter. Step one is simply irrelevant.
But that's not the case, Your Honor, unless this is an unusual circumstance that the court should not go through the analysis. That is what the Supreme Court said in Morrison, that the court has to go through, I'm sorry, RJR Nabisco.
What's the logic of that? I'm not following that.
The logic, Your Honor, I believe, is that but for the court finding that there is no extraterritorial application, we wouldn't get to the domestic application issue. That is not a question that this court would be asked to answer, absent a fact that
What if we say the extraterritorial issue is too complex and nuanced, and we think that it can be resolved under the domestic standard?
This court could say that, but I don't think we have a factual basis to do so here, as the court did in Harris, where the court would have to analyze subsequent amendments to the statute and whether or not there was a clear intention that it was to apply extraterritorially. It is clear that there is no language in 2251A and no references to any other statutes that apply. And I see my time is out, and I'll reserve the rest of my time.
Thank you. Ms. Bichara?
Good morning, or it might be afternoon at this point. May it please the court, Jacqueline Bashara for the United States. There are two approaches the court can take to resolve this case, but either approach confirms that 2251A properly applies to the defendant's use of an American child on American soil to produce child pornography. The government maintains that the text, legislative history, and purpose of the statute provide a clear indication that 2251A applies extraterritorially. But in this case, the court can simply follow its precedent in Harris and resolve the case at Nabisco Step 2, because this case involves a permissible domestic application.
Can you try to explain for me, I'm a little bit at a loss, why the necessity of the sequential analysis? Why would we have to determine that the statute does not or does, by its text, is extraterritorial when it applies domestically?
Your Honor, the court is not required to proceed in sequence. Both the Supreme Court in Western Gecko and this court in Harris said that the court has discretion to begin at Step 2 in, quote, appropriate cases. My colleague discussed unusual circumstances, but that text is nowhere in either of Western Gecko or Harris. She also suggested that Harris is distinguishable because the court had to consider the potential effect of later amendments on this court's existing precedent, but that was not the case in Western Gecko, right? The court was just deciding whether a provision of patent law.
Before you turn to Step 2, can you tell me, assuming we were going to decide Step 1 in the sort of normal process, how you distinguish Elbaz? I mean, which sort of addresses this argument that these jurisdictional hooks can't establish extraterritorial application?
A few points, if I may, Your Honor. So I understand that the court's concern about sort of general references to commerce and the same concern my friend identified, but we need to look at that in context, right? So starting with Aramco and Morrison, what the Supreme Court was saying, it was the petitioners in those cases were going outside of the substantive provisions and looking at overall definitional provisions that applied to Title VII in Aramco and to the Securities Exchange Act in Morrison. And that's where the Supreme Court developed this reasoning that, okay, a passing reference to commerce, a generally applicable definition of commerce.
Totally fair, but Elbaz expands that, right?
Right. And I would say that those statutes are distinguishable from what we have here because it's not a generic definitional provision that's applicable to an entire statute. And it's more than an isolated reference.
It looks like the wire fraud statute, right? It's like
similar.
in transmit in foreign commerce is the Elbaz language-ish, right? And it sort of same language appears here. Now it appears 3 times maybe, but I don't see how that makes a difference for you.
6 times in this statute. We know that Congress amended the statute in 2008 to add 2 more references to foreign commerce. So this is something that Congress was thinking about. And I think There are other indications beside the text of the statute.
You believe
We
this?
know,
Yeah, I gather based on that, your main argument is that this is extraterritorial?
I think in this case, the court can simply hold that this is a domestic application because the focus of the statute is on preventing harm to the child. The defendant has conceded it is undisputed that at all times the minor was located in Virginia when she received the defendant's communications and when she assented to engaging in sexually explicit conduct. And
Can you talk to me, or since you've got views on this, what the right unit of prosecution is under 2251? So imagine the scenario, forget the extraterritorial piece of this, but imagine the scenario where I used two minor victims to create one picture in one moment, right? It's an instantaneous, so it's one moment, one picture, two minor victims involved. Can I be charged for two separate offenses as the appropriate unit of prosecution, or would that be multiplicitous?
Your Honor, I have to admit that this is not a question that
Totally
I've
fair.
thought about.
Totally fair.
today. So it sounds like I would think one picture would be one count, but again, I haven't thought about that. I don't have a case to cite to you off the top of my head, so I'm happy to provide supplemental.
No, you're fine.
Okay. If I could respond to a couple of the points at the step 2 analysis. I know that my friend suggested that the focus is on the defendant because the statute uses this for the purpose of specific intent language. I think that's the wrong way of framing the focus for 3 reasons. First, it's just inconsistent with Harris, right? The court was looking at 2422B, which is similarly worded. It prohibits enticing or coercing a minor to engage in prohibited sexual activity. And the court said, as you know, the focus is on where the child is when she's coerced into sexual activity. It's not on where the defendant is located when he entices or induces or coerces her. The second point follows just from the text of the statute. My friend suggested that we should look at where the defendant was because of this purpose element. But if you think about cases like Morrison, where the court said Congress does not just prohibit deception by itself, right? What's prohibited under the Securities Exchange Act under Section 10B is deception in connection with the purchase or sale of a security. And similarly here, 2251A doesn't prohibit using or persuading for the purpose of producing a visual depiction sort of in the abstract. There has to be an object of that inducement or coercion. And 2251A tells us that the object is any minor. The third point I'll just note for the court is that the defendant's framing is just inconsistent with what Congress has been saying about the child pornography laws since 1977. We detailed that history at pages 37 to 39 of our brief. And I'll just highlight in 2003, in the PROTECT Act, Congress made the specific finding that production of child pornography is simply a byproduct of the sexual abuse of a child. So it's unambiguous that what Congress has been concerned about over the decades is preventing child abuse, not on this sort of mechanical act of taking a picture or recording a video.
Can you respond to your colleague's argument that each of these counts, though it indicates both production and transmission, that the to wit of each count narrows the indictment in some way to eliminate the language transmitting a live visual depiction? Do you understand the argument that's being made here? Right. What she's saying is you've charged both, right? So the indictment charges both producing a visual depiction and transmitting a live depiction. And her argument, as I understand it, is that yes, that's charged, but the to wit, which is the sort of last line, means that it's only the production that you're charging.
I don't think that's correct because...
Help me understand why that's not correct.
The government frequently uses conjunctive charging language because it can support either theory of liability. And the fact that we've identified a specific video file doesn't mean that the video file doesn't satisfy both of those means. the court has no further questions, we ask that you affirm.
I do.
Oh, I'm sorry. Chief Judge Gregory?
Yes. What about the enhancement?
Okay.
I mean, contact, and there was an enhancement for use of a computer, wasn't it?
I think there was.
And what about, is this the same thing? This extra one?
The sexual contact?
Yeah. I mean, because they weren't in the same room. They were in the same country. What was the first of all, you don't know whether or not you had the standard one, use of a computer.
I think that would have applied, yes.
Yeah, let's assume that it is. And what about this extra one here says contact? Okay, what? I'm asking, isn't that the same thing? Because here there was no real contact. Was it physical contact?
It was physical contact, the minor masturbating, which every court of appeals to have addressed this issue has held that masturbation is sexual contact under the guideline.
Right. But it's normally the contact that the other person makes, right?
Not under this guideline, given the way that Congress wrote 2246.
I know it already brought it, but isn't the other contact, the one that you don't know whether it's there, is standard, that deals with using a computer to further contact, which would include the masturbation you talked about and things like that that's not real touching. Isn't this duplicitous? I mean, it covers that. Doesn't it cover that? In this instance, because you don't have the physical contact, haven't you already accomplished whatever that contact is by either persuading someone to contact or touch themselves through the computer? Isn't that use of the computer? He's already been enhanced for that. That covers the contact in this case, doesn't it?
The use of a computer is one aggravating element, but the multiple videos in which he induced the minor to masturbate and recorded those videos, that's a separate enhancement.
No, but it covers it. That enhancement talks about using the computer to do those kind of things. All those things you talked about. And now you're just putting another layer.
Well, couldn't there be pornography without contact?
Could there be? I guess there could be. But the point, though, is that it's already I guess the Sentencing Commission, I guess they're looking at this, but I don't know how you can really accomplish this kind of child pornography without a computer anyway. It's almost like somebody being charged with having a firearm and then you enhance it because they had a firearm. Well, you can't commit the crime without a firearm, and then enhancement is something extra, right? You put the extra up there is you accomplish this by using a computer, which includes contact and the kind of things you talk about. Then you add another one on and say, oh, contact. I mean, at some point, the rule of lenity doesn't even exist anymore. Because obviously I think when you have things that protect children in a situation like that, we lose sight of what is the sense of requirement of what the rules occur, not just, vindication of what we consider to be and I agree with you, a detestable act. But isn't that piling on? We would call it when I was growing up. He's already down, but two or three other defensive linemen jump on top of him. Isn't that piling on? Yeah.
No, Your Honor, there are still.
How much time did he get?
252 months.
20 years.
21 years.
21 years for using a computer, right? I'm saying that's a whole lot of time, isn't it?
Well, the court also had to consider the aggravated nature of this offense in that he flew from New Zealand to the United States and tried to kidnap a child.
Wasn't he enhanced for that? Was that enhanced, or didn't say that's?
No, I'm saying.
Was he charged?
Was the district court's assessment in imposing what is still a below guideline sentence?
Okay. But you don't even know whether or not they used a computer here, right? You just assume that it does.
Yes.
It did. Okay. But you said even if it did, it's not duplicative.
It's not duplicative because Well, to go back to your,
Can I just ask you a question that might help add to the discussion? Computer contact is a form of contact, but the sexual contact being referred to here is the touching in a sexual manner.
yes,
And the courts have held that masturbation is a sexual contact.
yes,
There are other statutes if you have contact with the other person, but that's not here. This one is, so the enhancement is for inducing her into sexual conduct that involves sexual contact.
That's
And the
correct.
computer is a different enhancement because it's a form of contact, communicative contact.
yes,
Is that what your position is?
that's correct,
Yeah.
yes,
Okay, that's your position?
yes.
Okay, now, I want to try to get you to answer the question this time. When you do it with just the computer, what kind of contact is that?
That's not sexual contact,
What is it?
communication.
You mean the enhancement is because you communicated with someone?
The
Obviously,
use of
you
the computer-
can't commit the crime without communicating with someone. It's called an enhancement for a reason. It says use a computer, and part of that, right, is contact. I want you to tell me what contact is it then, other than, I guess maybe you said that's the answer. As long as if you talk to someone, that includes, that's a different aspect of it because it's using the computer and there's different ways to use the computer. All I'm asking you is, in this case, they use the computer for contact. I grant you that. But then they have a separate enhancement that say contact, which also includes, well, you entice someone to masturbate. Well, that would be included in the other one. You use the computer to contact someone and you persuaded them in that contact, a child, to engage in masturbation. Why is that not covered by that enhancement?
Because, Your Honor, the separate enhancements drive at two separate issues, right? So one is that the commission has determined that child pornography offenses that are facilitated by the use of a computer are more aggravated. And that's a policy judgment. Of course, the defendant has never attacked the application of that enhancement, so it's not before the court. There is a separate enhancement for offenses that involve sexual contact. And that's what's at issue here. And of course, that is concerned with some kind of sexual contact, something that is of an aggravated nature, but that's separate from using a computer to commit the crime.
All right.
At this point, if the court has no further questions, we ask that you affirm.
Do you have it in, I'm sorry, I'm just trying to make sure I'm following. The sexual contact enhancement is which one? That's 4B 1.5B1? I'm just trying to find,
2G 2.1B2A,
oh, I'm sorry, say that one more time?
2G 2.1B2, capital A.
And so that's part of the base offense calculation. I'm with you, okay. So it's not a specific offense characterization, it's part of the base offense? I don't have the guideline provision in front of me. I'm just trying to figure out,
Yes, it's.
like, I'm on the PSR, and I'm trying to figure out where that, thank you very much.
It raises the level 32 to 34.
So, sorry. But I guess I'm not totally certain where I'm seeing that being applied. Maybe what am I missing?
In the PSR.
Correct.
So the government objected after the
Thank you.
PSR
That's what I'm
was
looking for.
prepared to the failure to include the.
So it was added after the PSR.
Yes.
All right, thank you. Sorry.
Okay. I guess a last call for questions. All right. Thank you,
Wait
Your
a minute,
Honor.
last call, you're telling us, last call? We're finished. Go ahead.
Your Honor, just a few brief points, Your Honor. As it relates to the court's last questions about the specific offense characteristic, if this court were to find that there was an incorrect application of the sentencing guidelines, the government has argued that there would have been no harm to Mr. Skinner, and that is in direct conflict with this court's decision in Morehouse from last year. If there is an incorrect calculation of the guidelines, then that is the incorrect starting point for the judge
Right,
to
but help me
decide.
understand, I could readily concede, I may just have sort of missed this. But help me understand the argument that because there's a computer used, that covers the same contact as sexual contact, right? Because you could, in theory, you could use a computer to just get a nude photograph, right? And so that would be a computer without any contact. And so I'm not sure maybe I'm totally confused, so please help me if I'm not following.
That's okay. I think what I understood Chief Justice Gregory to be saying is that because this contact, this communication in which there was the depictions happened entirely on the computer, but for the use of the computer, that would not have happened. And so therefore, the use of a computer enhancement, which was separately applied, would potentially constitute double counting. I believe.
But so I guess I just don't remember that argument. But so why would, but that doesn't, but for doesn't mean double counting, right? Because you can use a computer to have contact, that is masturbation or otherwise, and you can use a computer to have no contact, that is a nude photograph.
Yes.
And so it seems to me, even if we're looking at that question, the computer question and the contact question are totally different.
So I did not raise that. We did not raise that issue in this case. I think it is a good argument that Chief Justice Gregory has made, but it's not something that we briefed or raised below.
Sorry.
But I want to turn the court's attention back to the language on the first issue of why this court has to engage in the two-step analysis for the extraterritorial discussion. If we look at the Harris case at 559, which is quoting.
Why does this matter to you? I'm totally perplexed by this.
Because it's an easy question, Your Honor. The court can't skip over the first question if it's an easy one. And I think that the government is.
Can't or shouldn't, right? Do you really mean cannot or do you mean should not? Maybe if you said should not, I understand that argument. But the cannot argument is the one that I'm having trouble with.
Well, what the Supreme Court has said in RJR Nabisco is that ordinarily courts should proceed in sequence, addressing step 1 first and step 2 only where necessary. And so the Supreme Court in RJR Nabisco specifically identified that there would be an appropriate case to go directly to step 2 if the case involved a step 1 inquiry that involved difficult questions that would not change the outcome. Here, that's not what we have. We have a very easy question that this court has basically already decided in Elbaz. And
we should read that portion of RJR as a command, that's the only time in which you can skip step 1.
I don't have any other examples that the courts have found that they would be able to step over aside from that circumstance.
I don't understand the logic of that. I hear your language, what you're saying, and it seems to me the court left a fairly large opening there for the court to make a determination, but I don't understand the sequential logic. In other words, the statute could say on its face, this applies extraterritorially, or the statute would say nothing of the kind, but would apply it. I mean, there's not even if you find that it's domestic, a violation, you don't even have the extraterritorial issue before you. That's my problem.
I think that the reason that there is this two-step process, Your Honor, is because there is a presumption against the statutes applying extraterritorial.
Fair enough. Let's leave that all alone. But the question is, if I have a crime committed where instead of this man being in New Zealand, he was in Pennsylvania, we wouldn't raise extraterritorial, would we?
We would not, Your Honor.
Okay. So the mere fact that he was in New Zealand, but all the rest was in Virginia, all of a sudden we have to determine extraterritorially?
Yes, Your Honor.
Even if we conclude the statute applies domestic, it is a domestic application?
Yes, because of the fact that our country has decided, along with many other countries, to respect the boundaries of the laws of other territories within the world. And
Well, I
so-
understand that, but if we conclude that it's a domestic statute, the guy shot from Canada into Vermont, you said that was a Vermont crime.
No, I said it would depend on the text of the statute, Your Honor. But
I said common law because I didn't, most murder statutes are based on common law.
well, but that's not what we have here. We don't have a common law, and I see my time is up,
Oh,
Your
well,
Honor.
statute will say it then, but my whole point is, a murder statute doesn't address extraterritoriality. Murder statute says one who shoots another with a certain amount of mens rea is guilty of manslaughter or second-degree murder, first-degree murder. And
Well, in that case, Your Honor, if the court was to find that the language was not sufficient to make a clear application of extraterritoriality, then the court would proceed to step 2, and perhaps in that circumstance find that the focus of the statute was on the harm to the victim in the United States. That's not what we have here. So I asked this court
I
to
can't understand why, but that's okay.
I asked the court to vacate Mr. Skinner's conviction in count 1, and I appreciate the court's time.
Thank you, counsel. Thank you both for your arguments. We appreciate them very much. I'll ask the clerk to adjourn the court until tomorrow morning, and we'll come down and greet counsel.
This honorable court stands adjourned until tomorrow morning. God save the United States and this honorable